It's an appealable order. Why will this court interfere? Find out whether it's appealable order or not. Otherwise, mention on Monday or Tuesday. I'll consider your submission.
Next emergency, my lord, I had troubled your lordship before the vacations. And my lord, leave to file two application, my lord, without the certified copy. We are
Why?
not-
When
we are
was the
not
order
being able-
passed?
My lord, the orders, the difficulty is both the parties have settled the dispute. Went to mediation. Mediation report is there. Filed an application under Order 23, Rule 3. Thereafter, also, my lord, for a year the matter has not been taken up. For a year, my lord, the matter is not being taken up for the disposal of the suit in terms of the mediation order. Now, my lord, we have wrote to the registrar of the concerned court.
Which court?
It was refused. My lord, it was passed by, my lord, Bidhannagar court, my lord. Civil Judge Junior Division, Bidhannagar.
Matter has not been taken up. Settlement has been reached by the parties.
No,
Degree is not been passed on the basis of settlement.
no, my lord. Two matters. For a year, my lord, we are in trouble, my lord. We have applied for the certified copies back in August 2024. We have been waiting till now, but my lord,
August 2024, you did not get certified copies.
we did not. We have also wrote to the registrar of the concerned court that particular, my lord, letter has been returned with the endorsement refused. My lord, grants us
Leave
leave.
granted on Tuesday.
I'm extremely obliged. Extremely.
Serve the other side.
My lord, I shall.
Yes. মঙ্গলবার দিন
my lord,
আপগ্রেডেড মোশন হিসেবে দিয়ে দেবে লিস্টে। না 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 লিস্টে দাও, মান্থলি লিস্টে লিভ করে মান্থলি লিস্টে দাও আর মঙ্গলবারের ডেট দিয়ে দেবে। It'll appear in the monthly list with the date of Tuesday. Yes, call the list. এটা কেন?
Lordship, I am for the petitioner.
Yes, madam.
Lordship. Petitioner do not want to proceed this revisional application, Lordship.
Yes, Ms. Chatterjee, learned advocate, appearing in support of the aforesaid revisional application by placing before this court the communication dated 20th November 2024 would submit that the petitioner does not want to proceed with the revisional application and seeks leave to withdraw the same. Full stop. Let a copy of the aforesaid communication dated 20th November 2024 be retained with the file. Let a copy of the communication dated 20th November 2024 as placed before this court be retained with full stop. Having regard to the submissions made, let the revisional application being CO 3538 of 2024 be dismissed as withdrawn.
Deeply obliged.
Yes, next.
I am for the petitioner. Senior is appearing on online.
My lord, item number 2, I am for the petitioner. My lord, last occasion, your lordship already extended the interim order till 31st of January.
Not in your proper attire. I'm sorry, I cannot see you.
My lord, my camera is on, my lord.
No, your camera, you are not in your proper attire. You are required to wear a gown.
My lord, kindly pass it over for the moment.
Sorry,
I am waiting.
not like this. This is very unfortunate. Since you're on video conferencing facilities made available, that does
Pardon me, my lord.
not be on your proper attire while addressing a court.
Pardon me, my lord.
You
Pardon
cannot
me.
sit for your drawing room and wish to address the court in the manner you choose.
My lord, there is some difficulties today. My lord, kindly then make it not today only.
Passed over for some time.
No passover. This is under the heading extension of interim order.
My lord, on this matter, interim order already extended till 30.
Already expired.
Already extended till 31st January.
Yes. Where is your affidavit of service? I'll vacate the interim order. Where is the affidavit of service?
My lord,
Have you communicated the order to the trial and
My lord, I am here, my lord.
to the trial court?
My lord, I am here with count, my lord. My lord, on 23rd of
Have you communicated this order?
yes, lordship, we have
Affidavit of
communicated. We have communicated to learned.
affidavit of service.
My lord, today I could not come due to there is train problem, so I could not reach the court. So
Is unable to produce the affidavit of service.
my lord, affidavit, my lord, letter is with
As
me, my lord.
directed by order dated 23rd December 2024, having regard thereto, let this matter go out of the list. Next. Your interim order is till 31st. That is the last date you will enjoy the interim order. No further extension will be granted to you. Yes.
Mr. Maulik in this matter, ma'am.
Yes.
Mr. Maulik in this matter, ma'am. Last occasion, this was extended by your lordship till January, and affidavit of service has already been filed before your lordship.
This is under final consideration. Yes. Proceed. 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 This is under final consideration. It is recorded.
My lord, title suit had been filed in the year 2016, and then the matter was to ex parte, and that order, misc case number 135 has been filed by the respondent in this matter. And I have challenged the order passed by London Civil Judge Senior Division 5th Court that the matter was heard but without allowing the limitation. The order has been passed, challenging that this divisional petition has been filed.
Read the place the last paragraph of page number 2 of the judgment. Do you have the brief with you, madam?
My lord.
Yes, place it. Page number 2 of that order, which is challenged before in the revisional application. What are you searching? You don't have the brief?
My lord, all the papers not set.
You come to argue in this fashion.
No, my lord, I'm coming.
Kindly assist her. Oh, what state of affairs going on?
First title is not there, order is not
Okay.
Assist her, assist her.
I have the copy of the
Yes, assist her with that order. She is unable to find out.
order and copy that.
Yes, that is there. Yes, second page. Kindly read out second paragraph, last paragraph of this.
I have considered the submission of
Then the next paragraph, the petitioner.
The petitioner judgment letter in this case has filed the petition for stay of the execution proceeding on the ground that the judgment letter has filed an application under Order 9 Rule 13 CPC for setting aside ex parte degree dated 3rd of October 2019 in connection with Directive number 90 of 2000. Undoubtedly, the instant miscase has been filed by the petitioner's administrator with expectation for obtaining an order for setting aside the expiry degree passed in connection with title suit number 90 of 2016. At this initial stage of this case, in absence of any material to the contrary, it appears to this court that the expectation of the petitioner judgment debtor is a bona fide one. At this stage, there is nothing in the record to hold that the instant miscase will not be allowed, and further, if the same is allowed, and in the meantime, if the degree is executed, then there is every possibility of legal complication and possibility of multiplicity of litigation.
Yes.
As such, this court, having regard to the entire aspect and the material placed before this court, is the opinion that there is merit in the petition.
Yes. Then please continue. Read the entirety.
At this stage, be it noted that the suit being title suit number was filed for eviction and recovery of house possession. At the time of hearing, that advocate for the petitioner, defendant number 1, has admitted that he is still in possession of the suit property, being a lawful tenant, but no document have been filed to show that the judgment debtor made payment of up-to-date rent. Therefore, considering the aforesaid facts, this court is inclined to allow the petition filed by the petitioner judgment for stay of the execution case subject to payment of occupational charge. Hence, it is ordered that the petition dated 23rd August 2022 is allowed on contest. Let the proceeding of title execution case being number 2 of 2022 be stayed till the disposal of the instant miscase, with condition that the petitioner judgment debtor shall make payment of occupational charge of rupees 2,000 per month till the disposal of the case. Petitioner judgment debtor shall make payment of the aforesaid charge within 15 days of every calendar month, either directly to the opposite party or through civil deposit challan. In default, the order of stay shall be automatically vacated. Fixed 30th July for hearing of petitions under Section 5 of the Limitation Act.
What is your grievance?
But without the Limitation Act, we have.
After he is evicted, he will, then the limitation will be delay
No,
will be
no.
condoned.
This should
Sir, what do you want?
This should have
Expiry
been allowed.
degree you will execute, and thereafter delay will be condoned.
No, my lord. Before passing any order, Section 5 application should have been heard. If the Section 5 is
Please
rejected,
understand, he was not aware beyond the prescribed period. That is why he has filed the application. The learned judge ought to have allowed the application along with this, which he did not. I will do so.
Lord, I have filed.
What you want? He will be evicted, sir. Tell me, sir. After he is evicted, what remains in the matter under order
No,
9
I'm
rule
not
13, sir? Sir,
First-
tell me, sir. Sir, tell me this. You tell me, sir. Order 9 rule 13 has been filed.
Yes. When?
What is the
After 3
prescribed
years.
period? What is the prescribed period? Prescribed period is from date of knowledge. Show me that is beyond this date of knowledge from the pleadings in the petition. I will reject it here and now. I will set aside this order, reject it, even his order 9 rule 13 will go. Show me from his petition, prima facie it would demonstrate he was aware of the decree and that he has filed it beyond the prescribed period. Show me that. Matter ends there.
My case
Are
is
you
of,
please wait? Did I call upon you?
my case is of not for non-service of summons.
Please, did I call upon you? So you were not aware of this. That is your case. Obviously, it is apparent. Show me that, sir.
Lord, I saw you the order sheet.
Then why section 5 will be necessary for this? Independent application, why will it be necessary?
But he has filed it.
I
he
may have
know.
filed it, sir.
He
It is,
knows
it
that
is
I have-
rolled into one order 9 rule 13. Sir, kindly come to order 9 rule 13, sir. I will come to his pleadings. I will check up his pleadings. But you are taking a risk, sir. By arguing this here, you are taking a risk.
No,
Because I will go into the merits of the order 9 rule 13 once you invite the court to go this far.
I'm
If
not
you
submitting, not
invite
to
the
the
court,
effect. I am submitting. He was aware of the fact.
then I will decide this here
advocate-
and now. Order 9 rule 13 also I will decide here and now. You are ready, sir? For final consideration, this matter is here. If you invite this court to go this far, this court will just not make an inquiry and limit it there.
No,
That
kindly-
risk you take, sir.
Kindly this thing, it is interpreted.
I will consider it here and now. I will consider it.
It is interpreted.
So you are ready and willing to argue on the merits of the Order 9 Rule 13 also?
No, that is
Because your
not-
challenge is not that.
No,
Your challenge is not that.
I am challenging the order.
You are saying that vacate his stay and thereafter his Order 9 Rule 13 will be hard. That is your challenge.
And that
Now
that
you
might
invite
be-
the court to go that far. The court will also decide whatever submit, whatever I
that
do,
court has-
sir, decide these difficulties, whatever I do, when I decide such a matter, even if I do not want to, I will trade upon the merits of the application under Order 9 Rule 13. That either will go in your favor or go against him, which is not really, the party should not invite such an
No,
observation at this stage
I'm not
because you will be
inviting.
losing forum. You will be losing forum.
I'm not inviting that.
So therefore, sir, stay is there. Let the Order 9 Rule 13 be heard out. If you do not, he cannot succeed. Order 9 Rule 13 will be, application will be rejected. I'll provide for that.
And occupational charge, my lord, only 2,000.
You receive
No, it should be not less than 6,000.
not less than 6,000 occupational
Yes.
charges
300 square feet,
of area where
Cosba.
what documents have you disclosed? I will direct the learned court to decide that issue afresh.
Yes.
Only to that limit? No, please
No,
I
no.
understand. That has not been decided. Order 9 Rule, this is a stay. Conditional stay has been granted. Finally, he has to get an opportunity. So you also know, sir, in a stay proceedings, final opportunity has to be granted to parties to adduce evidence if for the purpose of ascertaining what is the current market value. So I will open out that. Stay will continue till disposal of Order 9 Rule 13. The learned judge has made certain findings, returned certain findings. At this stage, there is nothing to doubt your bona fide at this stage. Now you have to prove your case that you did not have notice.
Has been disposed of.
Correct. I'll reopen this part only.
No, only thing, will not kindly see the learned trial judge has also made an endeavor. Both the parties are directed to come for expeditious disposal of the misc itself. Last line.
I will
Therefore-
direct the court to hear out the miscase within 6 months.
but
maximum.
Section 5 has to be condoned.
Section 5, I will consider here and now and condone the delay. Section 5 is not relevant. You make up your mind. You tell me, sir, what do you want?
Yes, Lordship. I leave it to your Lordship.
No, you do not leave it to me. You tell
No,
me
no.
what you want, sir.
It is not true. It will be bona fide. If it is hard,
On
Yeah.
merit, yes. Yes. sir.
appropriate forum.
Yes. I think that will be better. Ashok. And you want the you want the occupational charges to be revisited.
Yes.
That I will open it.
Let him file an
I
appropriate.
will, I will open it here. I'll grant him leave. I'll grant him leave from here. So the learned court will revisit. Sir, you are entitled to oppose. What is your difficulty? You suffered a decree, please don't forget it. Challenging. Challenging.
The learned trial judge should take up the hearing of the section 5 application.
That is there, you want back,
What remains?
all remain there.
Now after this, what remains?
But that has to be formally confirmed.
Only that will be done by
Add a
the,
line together.
I file an objection there. Let that be hard. I file the objection, that let that be hard. Whether it's knowledge or
I'll
not.
condone that delay. Order 9, Rule 13, you hear out.
Very good.
You hear out the Order 9, Rule 13 on merits.
No, section 5.
Even if
how
Section 5, what is
delay?
there? Section 5 is 4 days delay. I'll condone that delay. And you hear out the Order 9, Rule 13 on merits. Whichever way it goes, sir. I think it will be better. What allow Section 5. I'll allow the Section 5 and hear out the main Order 9, Rule 13. If he does not succeed there, square one, he has to establish. Now the onus is on him. Now the onus is on him. You have already demonstrated from the proof of service was already filed in this case.
No, I file objection to the section 5 application. That is there.
Sir, Section 5, 4 days delay, nothing is there, sir. I will allow the Section 5, sir. Order 9, Rule 13, hear it out. And 2000 variation, I will permit it there. Go there, it will be better. Yeah. I'll keep it. You will get it back tomorrow, madam, Monday. Yes.
My lord, item number 4, I am for the petition.
Yes.
What has happened in this case, my lord? Respondent, opposite party number 1 to 5 file and read petition before this court. And my lord, out of 1 to 5, my lord, 4.
Yes. What is your challenge? What is your challenge?
I have challenged, my lord. I have not given time, my lord, time to file these applications. Your lordship can see the order passed by the court. That is a page, the last order, my lord. That the application only, my lord, no reason is given. That section 151 of the Code of Civil Procedure, I filed one application of section 47 before the court to stay all proceeding, further proceeding, my lord. Because this is the case, my lord, where the writ applications, my lord, filed and division bench passed an order. On the basis of division bench order, my lord, they filed a execution suit. Though I have complied the order of the division bench.
A division bench order said
Yes,
that it shall
yes.
be order shall be executed as a decree.
But my lord, what has happened? It is in respect of only one person, one petitioner. All 4 petitioners, name of the 4 petitioners expunged. Where your lordship kindly see the order, page 22.
No, Mr.
They have
Bhattacharya.
Yes, sir. Your lordship kindly see, yes. Your lordship, page 22. Thereafter, they have not filed any fresh writ petitions. Only one writ petitioner was there, my lord. I have given chance, please to come and take money. Your lordship kindly
No,
see the
this is
order.
a money execution case.
Yes, the money execution case, my lord, for only 1%, but they have 5% filed the money execution case.
Where is the decree? Where is the decree?
Your lordship kindly see the file, the application, the page, my lord.
Decree means the division bench order.
Yes. Yes, your lordship kindly see they filed your lordship kindly see the page, last page, my lord. There is 5 persons, my lord. Your lordship can see the name of 5 persons. They filed the affirm the affidavit, they filed the application, my lord, execution case with name of 5 persons. My lord, only 4 persons has already been expunged. How they have come? For that reason, my lord, I filed an application on section 151. Please.
You are appearing for?
I am appearing for the principal of the college.
So you will not refund. You will not refund the fees.
Yes, only 1%. Yes, you will refund only 1%, but 4%, they were not parties in the writ petition as well as the division bench.
Moushumi, Hathi and others. Who are the others?
Others' name were expunged by the order of the court, page 22.
Page 22.
Yes. Of this petition.
22.
Yes. Passed by Justice Devashish Kaur-Gupta.
And thereafter they prefer an appeal.
Where
Where is the certified copy of this order? 9125 of 2019. Where is the certified copy?
9125 of certificate, that is that in the by applications.
Where is the certified copy?
This order. This
Page 30.
certified copy of the appeal, my lord.
Yes, the entire everyone was there.
Everyone was there, not, my lord, how it is
Sir,
possible?
appeal applications are admitted.
How it is possible,
allowed
my lord?
admission. The institute complain understandably we cannot direct the authorities grant certificate on however students together refund fees collected from the students. Students.
Only one. Regarding only one, but because my lord, all the writ petitions were my lord, expunged. Name of the writ petition was expunged. Were expunged. Students, my lord, that for that reason, my
Go
lord,
before Justice Sen.
yes, and my lord, I
Oh,
made-
seek
yeah,
a modification. Given me, sir.
already, my lord, I filed
Given
an
me, sir. I will not interfere, sir.
But my lord, in the case, my lord, in this case,
Sir,
my lord,
given
only
to me, sir. I will not interfere. So if you want a modification, go apply before this court division bench, sir.
divisions means will I file an application on review?
Yes, where is your application? What happened to that?
This is still pending. Still pending.
Mr. Bhattacharya, what happened to that?
My Lanet Junior is Millard watching the list, but no copies has been served upon him.
If the
Where is that application copy?
copy application.
Serve here and now.
Yes, by today, my lord, I will submit.
Now he serve here and now. Serve it.
My lord, the file is in my office, my lord. I am
Have you filed it?
Yes, memo number is there. Memo review.
Follow it. Mention it.
Nothing to mention.
No, you mention it. Finish it off.
Yes.
Finish it off.
Yes.
Millard, as of today, he wants stay.
Not granting any stay.
But my lord, in this case, my
Millard,
lord,
only one thing, Millard.
my lord, only. But my lord, the one thing is this, my lord, only application. My lord, they have not allowed me to file applications. Other
It
applications.
is still end of January. Sir, it is still there.
Yes.
So, having heard the learned advocates appearing for the respective parties, list this matter.
January.
January.
Well, 30th.
He has a right of, if he goes for a review, let him go.
Yes, yes.
You only mention the matter before the division bench.
Yes.
Justice Sen's bench is a division bench. It has to be constituted. The moment you get it, you can write a letter. So bench has to be constituted for that purpose.
Yes, today this bench is sitting, my lord, I will mention the.
Go and mention, finish it off.
I will mention today.
So if you succeed, you succeed. If you do not succeed, you know the consequence. I can't help you, sir, here. Yes, call the next matter.
May I please your lordship, madam?
Yes.
My lord, on the last occasion when your lordship was hearing the matter, lordship has asked me to, my lord, prepare a supplementary affidavit, my lord. Since, my lord, the matter was slated before the court below on 18th of December.
Yes, 151 police cell. What happened?
So, my lord, on 18th December, there was resolution in the local bar.
Huh.
So, matter could not be taken up. And now it has been fixed on 20th of February. Now, my lord, on the day when I made my submissions, my lord, it was not on the server. So, my lord, lordship has, my lord, directed me to prepare a supplementary affidavit. It is also now, my lord, subsequently, yesterday, my lord, when I, my lord, personally checked the server, the order is available now. The same thing, my lord, what I have stated in my supplementary. But, my lord, I had filed my lord's order dated 30.
No, resolution of the bar, you did not appear. Why are you blaming the court, Mr. Bose?
My lord, I filed my application for extension of interim order. The interim order was, lordship will kindly see the order. Now it is available in the server. After I had prepared. My lord, I had filed my lord's order on the same date. How I did not appear, my lord? I appeared. It was not taken up by the court below since there was a resolution.
And resolution, you did not appear.
My lord, plaintiffs files copy of the High Court's order dated 13 December. I filed it. If I hadn't appeared, how can I file that order, my lord? I had communicated my lord's order. It's been recorded in the order. It's not that I did not, my lord, appear, nor did I, my lord, produce the order of this honorable court.
And due to resolution of the local bar, the case is adjourned. Sir, don't tell us that local bar resolution the court takes on his own and say
Sir,
because
may
there is a resolution, I
may
will not pass an order, sir.
Now, my lord, it goes to 20, my lord, despite, my lord, producing this court's order, it goes to 20th of February. If my possession got what remains, my lord. Now, my lord, in the meantime, Lordship also directed me to serve this. Now, my lord, it has come back, they have refused the service even, my lord. The petition was served upon them. This is the envelope, my lord. It is Josh Saibke deben.
You are still in position. There is
My
an injunction
claim
order.
is very innocuous. Let, my lord, the police to ensure that my possession is secured in terms of the order of injunction passed by the court below. This is all I
I am
want,
not
my
too
lord.
sure whether you are in position or not. How can I direct that? An interim order is extended.
It's been extended till 20th of February.
Your interim order is there, Mr. Basu. Your interim order is there.
My lord, interim order is there. My lord, Lordship will kindly
Bring
see.
the other side.
I have served them, my lord. How can I bring them? I have served them. They have refused.
I don't know. Where have you served? Where is your service?
Well, I have given my affidavit of service, my lord.
How did you serve?
To the defendants, both the defendants contesting, against whom, my lord, the order of injunction is operating.
This is the affidavit of service.
Yes, my
No,
lord.
this is
No,
supplementary.
supplementary affidavit of service. And the envelopes, my lord, it has come back with the endorsement refused. I have given that, my lord.
Let a copy of the supplementary affidavit filed in court be taken. Let a copy of the supplementary affidavit. Copy not. Let the supplementary affidavit filed in court. ওই ওপরে না despite service none appears for the respondents.
My lordship will kindly keep this with the
Yes,
record.
yes.
এটা রেকর্ডে থাকবে জজ সাহেবকে দিন।
You ought to have stitched it along with the affidavit.
My lord, I did that. The department said, since it has come in a torn condition, kindly do not do it. Please produce it before the court.
Very well.
And there's the endorsement, my lord, of the
Yes,
postal
call the
authority.
next matter.
My lord, lordship has made it returnable.
10. You have one more notice, I'll take it up.
My lord.
Yes. Yes, this matter. দেখেছেন ডাকো Yes, Mr. Banerjee.
Unfair treatment meted out to him. We're feeling like Obimunnu in Kaliyug. Kindly will have a look at the other side. This is unfair.
You are the person who will respond, I am sure. You are the only person who will
It's
respond.
called symbiotic relationship.
Section 5 to be decided
Five, Millard,
on
this
the
is
basis of
17
trial on
years.
evidence.
Kindly see, Millard, the galaxy of lawyers on the other side.
Mr. Basu is supporting you. Mr. Basu is supporting you.
But I
But
thought
And Mr. Shah, you are there for?
27.
I'm in 7.
But similar.
Okay, one by after. Section 5 on trial on evidence, Mr. Basu, Mr. Banerjee.
I have something to say.
Yes.
Millard, my learned senior friend.
No, you tell. We had.
Millard,
I was only that I was not well on the last occasion. You remember. Now you tell me. I had facts he had indicated already on the last occasion. So you tell me.
Pilot hard of Mosha Marte Kaman Daga. Now Millard, the missile has come.
Symbiotic relationship.
Tell me, Mr. Banerjee. Section 5. What is to be done? Trial on evidence.
Pilot did not look at the records.
My lord, kindly, my lord, may I make a suggestion?
Yes.
My lord, kindly allow, my lord, the section 5, let the matter be heard on merits.
I'll hear him. I have to hear him for
No,
that.
no, my lord, that would be my lord, suggestion, my lord.
Let me
before
hear
your
him.
lordship.
How many days delay?
15 days.
Achha, show me your explanation.
Yes. My lord, kindly, my lord. No, no,
Which paragraph?
my lord, kindly, my lord, I'm on my matter, my lord. Kindly give me a moment, just one moment.
Yes, yes.
আরে দাঁড়াও, ফাইলটা বার করি। কি করেছে? ও জয়দীপ, My lord, kindly take, my lord, the section 5, my lord, application, my lord, which is, my lord, at page, my lord, it's annexure DD, my lord, to, my
Page?
lord, page, my lord, 7, my lord, 52, it starts. My lord, the body, my lord, is, my lord, from 755. Now, my lord, kindly come to, my lord. My lord, may I indicate, my lord, the order, my lord, was, my lord, of, my lord, 7th of October 2024, which was, my lord, under appeal, my lord, before, my lord, the lower appellate court. And, my lord, that appeal, my lord, was filed on 21st of November, my lord, 2024. Now, kindly come to, my lord, paragraph 7. My lord, kindly take, my lord, para 3 actually. My lord, 7th October, my lord, the matter, my lord, was moved ex parte, where, my lord, the impugned order was passed. My lord, there was no formal communication, my lord, of the impugned order. But, my lord, on 9th to October to 3rd November, my lord, we were prevented, my lord, from taking effective and appropriate steps. Then, my lord, after consultations were held, my lord, first initial advice was to, my lord, file, my lord, a revision. Now, my lord, kindly come to, my lord, paragraph 7. My lord, advice was not ultimately followed through. My lord, it should be not. My lord, there's a typographical error in para 7. My lord, Joydeep Chakraborty did not file a revision. My client did not. Somebody else did. Now, my lord, this is, my lord, the advice, my lord, was given. Thereafter, my lord, the appeal, my lord, was, my lord, filed. My lord, on 19th, my lord, we received, my lord, the certified copy of the impugned order. And, my lord, on, my lord, the 21st, my lord, the, my lord, appeal has been filed. Now, my lord, paragraph 11, my lord, I am coming, my lord, upfront before your lordships. My lord, is, my lord, a cut paste, my lord, from, my lord, and other, my lord, section 5, which is why there is a mistake. One of the other appellants, my lord, had, my lord, preferred, my lord, a revisional application, which was withdrawn. That paragraph, my lord, all are appealing against, my lord, that same order. My lord, this is, my lord, para 11. My lord, is, my lord, that civil revision, my lord, had been, my lord.
You did not file.
No, I did not file. This is, my lord, mistake, my lord, that I, my lord, withdrew, etc. My lord, and one of them, my lord, had filed.
Defendant number 4.
Defendant number 4, who, my lord, withdrew it. Because, my lord, it was not maintainable, there being, my lord, an appeal provision. And, my lord, he also, my lord, when he filed, he filed.
Just to come back,
Yes.
7th of October 2024, the order was passed.
Correct.
Now, you came to learn with regard to the order, formally, never formally communicated.
No, no formal communication, my lord, para 3, 4, and 5, your lordship says.
No, due to Diwali intervening holidays, Durga Puja prevented during this period effective steps. When did you come to learn? You have not stated.
Yes. Now, my lord, we came to know, my lord, on, my lord, the 9th, my lord, because, my lord, the banks, my lord, started, my lord, freezing, my lord, accounts, my lord, your lordship will find, my lord.
So, 9th is your knowledge.
Correct, correct.
9th of October.
Correct. Last working day, my lord.
9th of October was the last working day.
8th was the last working day, my lord, I think.
Acha. before the trial court. ও আগের ক্যালেন্ডারটা আছে, একটা আগের ক্যালেন্ডার আছে আমাকে তো দাও, 2000 আগের বছরের ক্যালেন্ডারটা দাও। I need to see আগের বছরের ক্যালেন্ডারটা দাও তো, আগের বছরের ক্যালেন্ডার। Very well. So it was during the vacation that you came to learn.
Yes.
Now court reopened on 4th, I presume. Fourth.
Fourth, my lord.
So thereafter on 4th, the court reopened and you filed the application, you applied for certified copy when?
My lord, I got it, my lord, on the 19th.
Application when?
My lord, I'll give you a lordship the date, my lord.
একটা প্যাড দাও না আমাকে, কাগজ দাও, যাও। Yes.
My lord, 18th.
18th. You applied on 18th.
Correct.
6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 17, 18, 12. 14 days delay.
My lord, I said, my lord, 15, my lord, that's
Applied. And then there is a delay in between that.
my lord, 19th we got a certified copy, 21st we filed.
19th and 21st. So 2 days delay there. 1 day. 19th is to be excluded.
1 day.
20th, 21 days delay. 1. So 14 plus 1, 15 days.
We've
So how have we explained this part between 4th and
My lord, kindly have a look. My lord,
paragraph? Once
yes.
again, show me that.
Yes.
4th and 18th when you apply.
Yes. Now, my lord,
Just show me that
yes,
part.
my lord, kindly come straight away, my lord, to my lord, paragraph 7, my lord, at page, my lord, 756.
Yes, I'm on that page. Opted independently.
My lord, 3 conferences, my lord, were held.
7 member, 11 member. So there was, according to you, there was some confusion whether a memorandum of appeal was required to be prepared or a revision.
Revisional, my lord, that,
Cases
my
you are
lord,
required to
yeah.
file certified copy.
My lord, that we applied, my lord, on the, for both we need to apply. My lord, in fact, my lord, your lordship will find, my lord, there was a change of advocate, my lord, there was, my lord, a prior, my lord, revision which had been filed. My lord, leave was given to file without certified copy.
And what is their objection?
Their objection, my lord, the 761, my lord. My lord, kindly come to 762 first, my lord.
Yes.
My lord, before dealing with allegations, my lord, para 2A, my lord. 2B, my lord, is, my lord, this entire thing about appeal is all irrelevant because an appeal does not lie. It's an order under section 151, forgetting the nature of the order that it's an injunction. And my lord, therefore, my lord, there is no question of any condonation because an appeal itself does not lie. Then, my lord, kindly come to, my lord, paragraph 5. My lord, at 763, my lord. My lord, third line. The appellant has not stated any date in which consultation actually took place, which is, my lord, I've shown your lordship, the 3 dates are mentioned. Moreover, no bills or any contemporaneous documents has been disclosed to support the fact that they had any consultations. As such, the appellant is called upon to produce contemporaneous documents supporting the fact that they had consultation with their erstwhile advocate who had advised them to file a civil revision, failing which adverse inference may be presumed.
My lord can ignore that.
No. My lord, these are, my lord, the objections, my lord, which have been taken. Now, my lord, kindly come 4 lines after that. It is stated that the appellant may have received certified copy of the impugned order on 19th. But however, the server copy of the impugned order was already uploaded in the official website of the learned court on 8th, and as such, there is no reason to wait for the certified copy.
Come to the order once.
Yes, now my lord, kindly take, my lord, 5th December order. It starts at page 848,
Yes.
volume 4, my lord. I don't know whether your lordship
Yes,
has
sir,
volume.
it's on that.
Yes, now my lord, kindly come to, my lord,
5th
page
December order.
5th December.
Yes, yes. Yes.
Now, my lord, written objections are filed, my lord, to both the section 5 and the stay. Lordship will find that, my lord, in the first 3 paragraphs of the order. Then, my lord, the respondents filed an application under order 19, rule 1, read with 151, on the grounds stated therein, specifically stated that a direction be passed on the appellant petitioner for adducing evidence on the application under 5 to prove the reasonableness of the grounds as stated therein. Then, my lord, the appellant put much emphasis for an urgency to hear the stay application, stating inter alia that such steps as taken by the respondents is nothing but a device to adopt a dilatory tactics so that the impugned order which has been obtained by the respondents in the learned not in clean hand do not get set aside. Learned counsel for respondents referring to the application under 5 submits that cause of delay as assigned is completely false, fabricated, which is apparent from the pleading itself, and the appellant's contention for condonation on grounds deserves to be tested in course of evidence and cross-examination. Otherwise, actual truth would remain on. On the other hand, the appellant verbally objected against the respondent's application. That application for has been filed as a precautionary. But my lord, there is, my lord, 15 days delay, my lord. I'm not going into here. It was argued that there is this by way of abundant caution. Now, my lord, kindly come to, my lord, 852. Upon hearing both the sides and appraisal of the application under Order 19, Rule 1, simultaneously on scrutinization of the contention as taken in the application, it appears that the application is supported by an affidavit, which is nothing but a declaration as to facts made in writing and sworn before a person who has an authority to admit. The affidavits contains parawise statements which facts are true and which are true to it. It is also settled that that an affidavit itself is not an evidence within meaning of section 3, but same can be used as evidence only for sufficient reasons. Court passes an order under so and so. Thus, merely the filing of an affidavit of one's own in one's own favor cannot be regarded as sufficient evidence for any court on the basis of which it can come to a conclusion as regards particular fact, etc. From the point of objection as placed by the respondents verbally, as well as by filing the application under Order 19, Rule 1, a question naturally arises whether the contents and the statements contained in the application under Section 5 are true, and if such doubt takes place, then reasonably the fact required for an inquiry, and the maker of the affidavit may require to submit his evidence on affidavit to prove the fact, submitting him for cross-examination. Procedure would be in accordance with principles of natural justice, as also according to procedure under so-and-so and Evidence Act, both of which incorporate. Hence, the appellant petitioner is provided with liberty to prove the controverted fact relating to application. Now, my lord, only controversy, my lord, raised whether these consultations were held, and my lord, should there be contemporary. And the case is that no dates are mentioned, when in fact dates have been mentioned. This is what it is. And my lord, it's not, my lord, delay, my lord, which is, my lord, something, my lord, which is, my lord, I have, my lord, a case, but I was, my lord, actually going to, যেটা ইয়েটা দিয়েছে একটি ফোন না কোথায় গেল সপ্তর্ষি কোথায় গেল যেটা বার করলে তাকে লিমিটেশন হিসাব হিসাব Hello, 2013, 12 Supreme Court cases. Page 649, my lord. Paragraph 21, kindly come. My lord gives the, my lord, guidelines, my lord. Kindly have a look. My lord, 21.1, subclause 1, my lord, there should be a liberal, pragmatic, justice-oriented, non-pedantic approach while dealing with an application for condonation of delay, for the courts are not supposed to legalize injustice but are obliged to remove injustice. My lord, the term sufficient cause should be understood in their proper spirit, philosophy, and purpose, regard being had to the fact that these terms are basically elastic and are to be applied in proper perspective to the obtaining fact situation.
So not on this, on the question whether evidence has to be laid for section 5.
My lord, 21.6, my lord.
Yes, yes.
Adherence to strict proof should not affect public justice and cause public justice, because courts are required to be vigilant so that in the ultimate event there is no real failure.
That is all. That is all.
My lord, yes, my lord, this is
Mr. Banerjee, he has already accepted one position on the last occasion, if I remember him correctly.
My lord is not hearing section 5 application.
No, on the last occasion, you have submitted before this court, if I remember correctly, that you are no longer insisting for trial on evidence insofar as section 5.
Let the section 5 application be decided, my lord, by the learned appellate.
That you had said on the last occasion. Very well. So let us not go that
Now, my lord,
far.
if my lord is getting into the merits of section 5 application, then my lord, I have got many a thing.
Yes, make your submissions, because today
But
you see,
yes.
Mr. Banerjee, at the end of the day,
My lord, kindly have a-
কিসের চেয়ে?
চেয়ার তো
না,
বসিয়ে
না,
দিয়েছে।
এই তো পেছনে আছে।
দিতে চাইছি।
Mr.
I
Banerjee,
think it will be better, my lord, if 6, 7 petitioner make his exam first, then he will reply. Same thing.
this is the same fact.
Yes, my lord, if your
Order are different, facts are different.
Identical.
my lord, may I just say one thing?
Oh, these facts are little separate.
No, it's the same, my lord, suit, my lord.
Uh.
Now, my lord, I want to tell your lordships, my lord, one thing. My lord, Calcutta Rescue, my lord, is a very, my lord, well-known organization. My lord, it looks after the poor. My lord, provides street medicine. My lord, employs doctors, employs staff. And my lord, your lordships might remember, my lord, for over 20 years, my lord, a member of our Bar Library Club, my lord, led this organization, my lord, Mr. Gautam Chakraborty. He's no more. Now, my lord, it's a very reputed organization. Sadly, my lord, with regard to its management today, my lord, a dispute has arisen. The suit which was filed, my lord, related to, my lord, a special general meeting by which, my lord, some persons, my lord, were removed from the governing council. My lord, that was of 30th of September. Now, my lord, after, my lord, that happened, my lord, on the basis of a requisition meeting, my lord, of this society, it's a society, my lord, registered society. My lord, what happened, my lord, was a suit was filed challenging, my lord, three things. The requisition, my lord, the notice after the requisition was not acted upon, and, my lord, the special general meeting where the resolutions were passed. Now, my lord, the, my lord, matter, my lord, after this challenge, an application was made, my lord, by the other side, the plaintiffs, my lord, to seek, my lord, an ex parte order of injunction. My lord, on two grounds, my lord, it was denied. My lord, first was whether a civil court can at all, my lord, go into, my lord, the affairs, my lord, of a society being governed by the Societies Registration Act. There's a prima facie view that civil court would not have jurisdiction. Second, and this is, my lord, very important, my lord, it says, my lord, in any event, there is no prima facie case. So this was, my lord, ex parte refusal. Now what happens? My lord, there is, my lord, a communication, my lord, in writing of the resolutions which have.
Because there is no prima facie
Yes,
case.
yes. My lord, this is what has happened here. That's what I want to tell you, Lord.
Once it records there is no prima facie
Yes,
case, then
correct,
order can be
correct,
passed.
correct. Now, my lord, 7th October, my lord, what they do is they have the same case. My lord, challenging all these three things. Now, my lord, they say we are producing a document to show that this resolution has been passed, and, my lord, and, my lord, no, my lord, it's the same. My lord, facts remain the same. It's only a document which is given. So, my lord, on the basis of a document, my lord, the fact, my lord, is still the same. They give an additional evidence.
Will not go into the merits of it.
No, I'm not.
Because if I do that, that
My lord,
will
I'm
not.
not.
be
I'm just giving your
prejudicing both
lordship.
the parties.
No, I'm just giving your lordship, my lord, a
Overview.
my lord, why, my lord, this? Now, my lord, there, my lord, noticing, my lord, that he had refused, my lord, an order earlier, he said because there are subsequent facts, when there is no subsequent fact, my lord, he passes, my lord, an order of injunction, forgetting about, my lord, the jurisdictional issue also. And again, ex parte. And, my lord, then, my lord, what happens? We go up on appeal, and the story is now before your lordship. My lord, now, my lord, on the basis of that order, my lord, what is very important is my lord, bank is communicated. There's a debit freeze. Today, my lord, the society has.
That was the consideration. It upgraded the.
Correct. I'm grateful, my lord.
Correct.
Today, my lord, there is 1 crore 70 lakhs, my lord, which are
I
outstanding.
will not go into today.
My
That
lord,
issue I will not go into.
no, but your lordships can. My lord,
That I will,
if my, no, no, my lord, may I put it this way? If my learned
Because
friend
today
wants
that
to,
will be.
my lord, if
There
my
is
learned,
scope. I'll be assuming jurisdiction of the appellate court completely, sir, in that case, sir. Sir, perhaps that would not be.
no, your lordships have a
Definitely some
discretion
things-
whether to do it or not, but there is no
I
bar.
will take up the
My lord, my lord,
for the appellate court itself entirely.
my lord, may I tell your lordships? My lord, your lordships, my lord, can do that. But I am, my lord, giving your lordship, my lord, why, my lord, it's so, my lord, urgent. So, my lord, I am humbly praying before your lordships, my lord, my lord, kindly, my lord, allow the section 5 and my lord.
I'll give you enough protection for that.
Correct.
But
And my lord, they should,
you
my
see,
lord, decide it
I'm
within
very
a particular time.
I'm very expressive, so I'm clarifying my.
No, it's good to have a talking judge, my lord, just as Anil said.
No, it is very difficult also.
No,
Other
no,
way
no,
around.
my lord, we must know how the court is thinking.
No, so you see, if today I make any observations, qua the merits, that might prejudice his client and your client. I do not
Possible.
know which way it is.
Yes,
So let us not go that far.
very well.
Today, the order says that it has to be tried on evidence. So, one hand, your appeal is kept pending.
Correct.
It is waiting in the wings, is under the waiting list. And on the other hand, trial and evidence will go on for hearing of the Section 5 application. So, that aspect needs consideration, and that is I'll be considering.
Now,
Subject to hearing Mr. Banerjee on this.
yes. Now, my lord, may I indicate?
Yes, yes.
So your lordships, my lord, will not take the appellate court's jurisdiction. Now, my lord, if your lordships, my lord, ultimately hold that, my lord, section 5, either your lordships may allow it here, may not allow it here. If your lordships leave it, my lord, for my lord being considered there without now, my lord, trial on evidence, because my learned friend has fairly, my lord, at least made that concession that no
Yes,
trial
yes.
on evidence. Then, my lord, during the pendency of the 5, they should consider my stay application, because that can be
It
done.
will give you enough protection
Yeah.
so that
Yeah.
you are protected either way.
Correct.
I will hear Mr. Banerjee because you have really challenged this order.
My lord,
Your
two things I've
challenge is arising out of consideration of your Section 5 through trial on evidence.
Yes. My lord, that is one.
That is the difficult
No,
part.
that's one. That
Yes.
is one.
Yes.
That is one. The second thing I've challenged is, my lord, refusing to exercise jurisdiction to hear my stay application while a 5 is pending.
Then I'll provide enough protection for you. Even if Mr. Banerjee, I'll hear Mr. Mukherjee, let me hear Mr. Banerjee.
Very well, man.
So let me understand what he has to say on this.
Correct.
Because after all, at the end of the day, there is only 15 days delay. But he might say that in the 15 days, a right has already accrued in my favor. Such a right, he might say, sir, he may have many. I can't stop him. No. You can't stop him there. So he might make submissions. So yes, Mr. Van.
Just one sentence.
I'll hear all of you. Let me understand what he has to say. I'll come back to you, sir. Everyone. Let me hear what he has to say. Because you are really Mr. Kaur and Mr. Shah, both of you are sailing in the same boat. And I presume I have not read the other orders. This order is the same copy paste in other orders and in same. Then Mr. Kaur, let him make submissions and you'll, yes, Mr. Kaur. Yes, then Mr. Kaur.
Because they're saying, one is that we are in a jurisdiction under Article 227. Your Lordship is exercising a jurisdiction under Article 227. If your Lordship feels that the trial court has failed to exercise its jurisdiction, which is vested in it, not only your Lordships can make it right, but your Lordships can go further and pass the order which the trial court should have passed. This is one principle on which, Lord, I want to make submission. Lord, the pressing facts are, there are 513 critical patients whose medical cause has to be looked into.
Yes.
This has been continuously done by this institution, and Lord, details are at page 652 to 655. How these 513 critical patients are being supported. Today, my lord, if my blood pressure medicines are stopped or my dialysis is stopped, Lord, I can't survive. So, my lord, there are cancer patients. In fact, my lord, there are categories, my lord, which are mentioned in these pages 652 to 655. Therefore, my lord, this doesn't brook any delay. This is, my lord, an institution which has, my lord, over the years earned reputation for, my lord, standing by these patients. Now, 600 and 513 patients, blood, their blood pressure medications, some of them, Lord, are undergoing, Lord, the dialysis, Lord, that has stopped. The freezing of a bank account, Lord, suit is filed by his ex-secretary who is suspended. I can understand that he is espousing his cause, but Lord, the society has to run. The show must go on. There can't be a complete shutdown of the entire process. The bank account freezing, that too, Lord, not on the first day, on the second day, by order of 7th October, freezing the bank account. I can understand, Lord, saying a temporary stay on the suspension, which is challenged in the 151 application. But this is a completely chaotic situation.
Let me hear Mr. Banerjee and Mr. Shah on the same line. Mr. Basu.
Just add, only add.
Mr. Basu.
Sorry, I'm sorry.
Just I want to add. So far as the urgency, Mr. Kaur has submitted.
Yes.
Kindly come to 419 of item number 70. The impugned the order.
Item number? Item number?
7. Next one.
Hey, 45 that. 419, same page.
Kindly take 490. Kindly come to order dated 5th October 2024.
Previous order.
Kindly come to the page 420, last part, one paragraph.
Order.
This is ex party. What is the consideration of the court? The plaintiff alleges that the defendants have removed the plaintiff from the governing council in such meeting, but a document is placed on record in support of the same. The plaintiff further alleges that the website of the society as well as the email of the society have been hacked.
Where are you reading? Where are you reading?
The impugned order, 5th October 2024 order.
Yes, which line?
The last but two paragraphs.
Yes. Upon hearing learned advocates?
No.
Page 420. Page 420. Oh, okay.
Page number is bad. That's not.
It doesn't matter. Yes. Further, the plaintiffs have that.
Yes.
Place it. Yes, please.
Apart from the apprehension of the plaintiff, that those acts have been done by the defendant. Stop. Then.
Yeah, I got it.
Even if those were done by the defendants, the appropriate forum for agitating such issue is my view cannot be a civil court by any civil suit. The court of the opinion, the civil suit is not maintainable. Then, in such circumstances, I do not find strong prima facie case also. Because if the suit is not maintainable, no prima facie case. But to that matter, I want to cite one judgment for lordship consideration.
No, I will then touching the merits, Mr. Basu.
I am adding to this submission made by Mr. Court that the urgency. If the urgent situation is this, where the court should not have passed any order.
The moment I say so, I appreciate Mr. Basu. If I make any observation that having declined to pass an order in the same facts ought not to have passed this order, I go into the merits of the case and I leave the court, stay the order.
Absolutely correct. But in the interregnum, my lord is exercising power under 227.
Then I have to consider whether or not to at all grant you stay in this matter.
We ask your lordship to go into this. I have a judgment, my lord. What the honorable.
No, I am not saying that the court is not empowered to do so, but whether in the given facts where the sanction file is pending.
Endeavor is to show to your lordship in the given facts and circumstances no injunction. That too, to the extent of
injunction, I will leave it to perhaps Mr. Basu and very clear. Injunction, I will leave it to the trial court.
To that extent, what the society can run.
To stay up, not the injunction, the stay of the injunction. I'll leave it to the trial court. I'll give you enough protection. Enough protection that it will decide on that date.
What should be in the interregnum?
I'll fix a date. I will fix a date before the trial court.
Account has been seized.
Yes. You have waited. Now you have waited. You did not move the vacation bank. You have waited. No, I understand. Yeah, I understand. Now you see, I will fix a date before the trial court. And the trial court will hear out subject to hearing Mr. Banerjee. I'm sure he will not object to the trial court hearing out the matter.
My lord, your lordship
Huh?
knows
Then,
the nature of the injunction has been passed. Is it?
then Mr. Vasu, then they were taking up today, if the High Court passes an order in this matter, then what remains for the interim order is passed. The appeal not remains in the appeal.
But one sentence.
Then nothing remains in the appeal.
Since the nature of injunction has been granted,
Yes.
but kindly consider one thing.
Yes.
This is in aid of the suit. This is the basic principle of law. The interim order should be passed in aid of the suit. Can you see the prayer in the plain? This injunction.
For that, you have to wait for one more stage, Mr. Vasu. Till such time, any order is passed with the appeal court, I will not perhaps entertain.
The court, trial court found that there is suit is not maintainable. Prima facie. And the second day, the appellate court, without adhering to that point.
Very well, very well. Let me hear, Mr.
Appellate court, same court. Appellate court, same court.
Yeah, understand.
Then court passed an order.
I will not repeat anything.
Yes, yes.
I really want to point out one thing. Your lordship has been told, my lord, that so far as the jurisdiction is concerned, if there is failure to exercise jurisdiction,
Yes.
that's a revisable, my lord, action. Now, my lord, your lordship does not want to sit in appeal. I also quite appreciate that. But, my lord, what is on record is the fact that the bank account stands frozen. And, my lord, the purpose of this society is to, my lord, care for the sick and the poor. And, my lord, that about purpose.
Where are those attachments?
Yes, yes.
Order?
All
Just,
the
just.
attachments
No, naturally. Just
the bank.
pages. Just give me those pages. Just page.
650.
650. 462 onwards. Yes, yes. Just 1 minute.
464, your lordship straight away.
I've got one. 460.
Can you come to 464, but I don't want to trouble you with all the letters.
Yes.
This is what is communicated. And this is what the bank writes to us, reading from Standard Chartered Bank.
Yes, yes.
This is reference to various communications received by the Standard Chartered Bank at such and such. It may please be noted that signature is on record for the account such and such. And 18 fixed deposits held in the name of Calcutta Rescue with such and such.
And debit freeze. Yes.
Now, we have received the communication on 19th October 2024 from Mr. Amitabh Poddar and Sanjay Sapru, who are the mandate holders in the account, informing us that from the change of signatures instructing us to initiate a debit hold in the account. Please note that a debit freeze was placed in the aforementioned account since all communications sent to us today indicated that there is a dispute among the mandate holders and the mandate subsidiaries for a court of law. Then kindly have a look at 469.
My lord, just the next 4 lines. Kindly see, my lord. To avoid any claims from place a debit freeze, we request you to provide a revised mandate to the bank in supersession along with a clear court directive. They want a court order for operation. Kindly see, my lord. This is what has happened now.
That also have a look at 469.
Not the 416. Doctor that requesting.
Well, these are, my lord, communications that, my lord, the society is now receiving. Well, there's entirely come to a standstill. Please see, here Ruby ma'am, some of our important suppliers who are supplying to us life-saving medicine are telling us that they are not receiving payment for a long time. We need to clear the payment immediately, otherwise they are not supplying medicine and vaccines further. Suppliers like Shatantar sent a mail that they have more than 4 to 5 lakhs outstanding balances. On behalf of the pharmacy team, we are requesting to otherwise, we cannot supply medicine to all the clinics in a regular manner. As we know that our patients come from very poor families, they cannot afford the cost of life-saving medicine. Now, all that I am saying is,
urgency has been, Mr. Kaur has indicated this.
I want to say one thing. Now, my lord, your lordship need not sit in appeal at this moment, as your lordship is indicated. But my lord, here, well, although this is a society registered under provisions of the Societies Registration Act, well, this is for all effective purposes a constructive trust of a charitable nature. And my lord, there, my lord, a Supreme Court judgment of our High Court, where it says that the court, well, it sits in a participatory jurisdiction so far as such societies and charities are concerned. Now, my lord, I am saying that don't reverse the order of injunction, but please appoint a special officer or my lord, an administrator through whom my lord, these important expenses can be defrayed. Otherwise, my lord, the entire purpose of the society, and my lord, kindly see.
You made a prayer for that in your petition.
Well,
No. In your petition, made a prayer. No, prayer. Is there any prayer?
Prayer is for CA, but my lord, your lordship can always hold that.
Very well.
We are only saying that let the kind to also see.
I'll record your submission.
Bothered with the functioning of the society. They are only bothered with the control over the finances of the society. So, all that I am saying is, let the society function
if necessarily, my lord, through checks and balances imposed by this honorable court, till the matter can be heard. If your lordship is not inclined, immediately pass an order which will, my lord, effectively, my lord, overturn.
Yes, Mr. Banerjee. Mr. Banerjee, same thing, same one. Yes. Page. 52.
Stay of 7th October as well. The Mullah has already seen
para 50 ta देखिएगा para 50
Paragraph
22 para
page
50 पे
22 para 50.
Yes.
Page 22, with the sudden imposition of debit to the malastic activity of the concerned parties, whereas DC is unable to utilize the funds lying in the bank of society, or this amount of 1 crore 8 is due and payable as per the following.
and my lord today it's 1 crore 70.
Medicine supplies, nutrition, other care items to beneficiaries, and all that.
And where is the plain, Mr. Banerjee? Plain. Which page?
Page
312.
You want to at 326.
Yes.
I just one sentence, just to conclude, kindly appreciate the fact that on the 5th, if a court says there's a jurisdictional issue and refuses to pass an interim order, ex parte on the basis of no prima facie case, on the 7th of October, under no circumstances, that same court, ex parte could have passed any order. And that is also under challenge. And is exercising Article 27 jurisdiction. It is far reaching. It is really to look after that.
There are two aspects to this. One is that once this court passes any order of injunction today, not injunction, stays that order or modifies it, affords protection to the parties. Difficulty is that the trial court will not the trial court. The first appellate court is not going to touch that. And the matter, today you are in the injunction stage where you are yet to file your written objection. Please understand. So matter has to travel back. Matter has to travel back.
Written objection in the defense. First, someone has to make
No. Matter has to travel back. Your matter has to travel. It is not for the appellate court also to decide this.
May I just submit this one?
Yes.
But the grievances today were not blocked. I went up in appeal. I wanted a stay of 7th October.
Correct.
The court, instead of hearing and staying there, has said that no, I shall now try Section 5.
No, that's sir, I have understood.
Agreed by that.
Yes.
That's also an issue. That's one of the prayers I wanted to show. It's not a question about stay of both 5th as well as 7th. Kindly stay 7th. Why should 7th October should have been passed in view of 5th October? What has happened? It's absolutely an abuse of the jurisdiction. Kindly do that. That's what we are here for. I'm not going further, saying 7th October should have been stayed. The appellate court should have exercised jurisdiction, looked at 7th October and said, under no circumstances, after 50 would have passed that order. And should have stayed 7th October. That's what we are agreed by.
Let's see. Yes, Mr. Raji.
Only one order is under challenge before your lordship. The order is 5th of December 2024. The order of 5th of December 2024 was preceded by an order of 26th November. Can you just have a look at this? May I just show it to my learned senior? 26th of November. 5th of December order is under challenge before your lordship. One order is under challenge in the revisional application. This order of 5th of December, which is under challenge today, was preceded by an order passed by the appellate court on 26th of November. I have only one copy. My lord, can you just have a look at it? Yes. My lord, will kindly just have a look at the last paragraph of that order. Considering the urgency of the matter fixed on 3rd of December for hearing of the limitation application, followed by hearing of the stay application subject to the fate of the limitation application. My lord, this order has been accepted by both the parties. This is not under challenge. So, my lord, appellate court said, I will hear the section 5 application. Subject to the fate of the section 5 application, I will travel to the stay application. This is accepted by all. Today, my lord, my learned senior friends, after having accepted this order, cannot come and, my lord, argue that, my lord, section 5 application is to be heard by your lordship. My lord, taking, my lord, the jurisdiction, my lord, from the learned appellate court. My lord, I know that, my lord, the jurisdiction of 227 court is, my lord, far-reaching, wide enough. But, my lord, there is, my lord, a self-restraint always exercised by, my lord, the honorable courts. Is, my lord, for the learned appellate court, my lord, to take a decision whether, my lord, this delay should be condoned or not. My lord, that is a discretion, my lord, which the learned appellate court is, my lord, having. That discretion, my lord, cannot be snatched away, my lord, like this. My lord, we are ready to get, my lord, this section 5 application hard. My lord, even today, if my lord so desires. And, my lord, so far as the witness action is concerned, my lord, I am fortified by decision which say that section order 19, my lord, can be, my lord, made applicable to, my lord, a section 5 hearing.
That is a different issue altogether. Are you going back on your previous stand? That's why I asked you.
No, my lord, I stick to
at
my
the
stand.
very first
I stick
instance.
to my stand that,
Yes.
my lord, witness action we are not insisting upon. Witness action, my lord, we are not insisting upon. Kindly, my lord, just have a look at, my lord, the impugned order once more. My lord, only an affidavit, my lord, was required from, my lord, my learned senior friend's client. Only an affidavit. Kindly just have a look at the impugned order, the ordering portion. My lord, why are they feeling shy of doing that? Kindly, my lord, have a look at the ordering portion. Push up or
No, this is subject to cross-examination.
Kindly take page
Yeah, he's
852.
saying, Mr.
Kindly take page 852.
Yes.
Hence, the appellant petitioner is provided with the liberty to prove the controverted fact relating to application under section 5 by submitting evidence on affidavit prior to its adjudication by this court, thereby submitting himself to cross-examination. So, milord, it has two parts. One is, milord, filing of an affidavit, and then he exposes himself to be, milord, cross-examined by us.
The petition was supported by a verification on an affidavit.
Affidavit. Now, milord, there are amendments made. I will take your lordship to the section 5 application. Today, milord, Mr. Mukherjee will learn.
No, so you want the section 5 application to be heard out. I'll hear it out.
Yes, milord.
Then you want the court to hear out the section 5 application also.
I do not. But, milord, since section 5 application has been placed and, milord, a submission has been made that, milord, that's a typographical error, which is, milord, not correct.
But you are ready and willing to have,
milord, wrong statement,
misleading
misleading statements were made.
You are ready and willing to have
the section 5 application to be
whatever is there along with the stay application heard out on that on a very next date.
On today itself, milord, I submit.
I'll fix it before the trial court on next Tuesday.
Before the learned appellate court.
First appellate court on next Tuesday.
No, that's not possible. I tell you, lordship.
He will hear out, Mr. Mukherjee. He will hear out the application under section 5 on the very date, and thereafter, if he chooses to reject it, it is a different issue. If he allows the application, he will hear it out and dispose it up on the very same date and hear out the stay application.
If he allows,
unless he chooses to reject the application under section 5.
Yes, now, my lord,
I am not going to that.
Yes, now, my lord, I have
very next Tuesday he'll do it.
My lord, I have only one prayer there.
Yes.
One prayer.
Yes.
If he, my lord, does not pass an order on the section 5 that day,
yes,
my lord, he should hear our stay application.
Yeah, I'll provide for that.
He has to hear our
yes, I hear out and dispose it off on the very same date. I'll provide for that.
Peremptory direction, milord, to pass.
And I can do this. I can give him a little more time. Mr. Mukherjee, I can give him a little more time till Friday. Tuesday, I'll fix the date.
Today, my lord,
No, Tuesday, I'll fix a date. Tuesday, I'll fix a date. Matter will be heard on Tuesday. By Friday, he'll dispose of the section 5 and the stay application. Unless he chooses to reject the application under section 5. Unless he chooses to reject it. If he chooses to reject it, then the question of section 5 stay will not arise. But if he does not do so, then he will hear out both the stay application and the section 5 and dispose it up by Friday. I have to give him some time.
And my lord, in the
some time, you see.
No, in the inter-exam, kindly provide, my lord,
and the parties agree to that. You should agree to that.
No provision, milord, for the interregnum. during the interregnum.
What interregnum?
My learned senior friends are, my lord, asking for some kind
Why
of.
they are
I
they are
am, my
praying
lord,
for that.
praying for it.
Yes, they are praying for that.
Yes, my lord, your lordships can, my lord, of course, reject it. Now, my lord, I will cite one judgment why there has to be a provision in interregnum. Now, Jagannathan.
Mr.
No, I am serious about this. I would not have trouble.
1 week's time will not make a difference. 1 week's time will not make a difference.
My lord,
Just a week's time will not.
my lord, kindly give me 2 minutes, my lord.
Yes.
My lord, I am saying today the donors have said that these persons, my lord, they will, if they are in control, my lord, by the way they have created the disputes, the funding will stop, including Government of India undertaking.
Very well. I shall provide that in the event he chooses not to reject the application under Section 5, then he will consider grant of protection and interim protection on the very date itself.
Yes. Yes.
Yes, but
what
what
today I cannot go to and say that
that's what I want to show your lordship, my lord. Just give me Jagannathan's case. My lord, a lot has been said, my lord, on jurisdiction. No, my lord.
Whether you not even, my lord, open my submission, my lord, on the.
Please don't open your submissions. You are in difficulty, Mr. Banerjee. Yes. Yes, Mr. Mukherjee.
Because, my lord, what has happened here? My lord, just kindly don't look at papers, nothing. My lord, what has happened here, my lord, is, my lord, today, my lord, a group which has taken over, my lord, this, my lord, does not, my lord, enjoy the confidence of any of the donors. My lord, who are the donors? My lord, they are international chapters, my lord, of this, my lord, institute who have been donating funds. Number 1. Number 2, they are government undertakings. Number 3, my lord, they are, my lord, all companies which are carrying out CSR activities. They have given letters. Doctors have said that patients will die, my lord, unless, my lord, the funds, my lord, are, my lord, released. We have, my lord, 513 patients. My lord, it's street medicine. Now, my lord, we have students, my lord, who we educate. My lord, their fees are not being paid. My lord, free meals, my lord, which are provided. My lord, this state of affairs, my lord, has gone on, my lord, for over 3 months today. My lord, 1 week, my lord, is, my lord, critical because, my lord, from 1 crore 3 odd, my lord, it's 1 crore 70 today. And the plaintiffs, my lord, what do? They, my lord, injunction was you do not operate the bank account. What they write to the bank is you freeze the bank account. My lord, are they interested in the society and its purposes? Or, my lord, there is something else, my lord, which is happening. My lord, kindly, my lord, appoint anyone, my lord, to look at these and, my lord, disburse, my lord, the payment. I don't want to operate. They should not operate. Court, my lord, in the interregnum should see this. My lord, electricity, my lord, rent is not being paid. My lord, kindly see what's happening, my lord, to this organization. And, my lord, the appeal is from the doctors. My lord, their letters, my lord, are also on record. My lord, that is what I'm saying, my lord. Why, my lord, in the interregnum?
Should I, my lord, make
And,
a
my lord,
submission on this?
and, my lord, I'm just, my lord,
yes.
just,
No,
my lord, just one, my lord, paragraph I want to, my lord, rely on. Para 21, Shirona. My lord, kindly take, my lord.
If my lord is at all, my lord, partially.
Please, sir, kindly wait, sir. Your difficulty is there. What difficulty are you
Lord,
facing,
kindly
Mr.
take
Banerjee?
para 20, my lord. Just kindly
Senior
take.
is arguing a matter. Mr. Mukherjee is much senior.
No, my lord, he is, my lord. Everybody, my lord, should be treated at par, my lord. I'm against this.
No.
My lord, seniority, my lord, should not. My lord, kindly come to, my lord, para.
Seniority would certainly prevail while advancing arguments.
No, my lord.
But while treating equally,
Lord,
yes, everyone will be
Lord,
treated
yes.
equally. Yes, that is certain.
My lord, kindly come to para 20 at page 692, my lord.
Yes.
Now, my lord, kindly come to 693, my lord.
Yes.
My lord, last 7 lines of, my lord, the of para 20. And, my lord, this was concerned with the 226. My lord, subsequent judgments are there that 227 par is wider in this regard. Now, my lord, kindly see. In all cases and fit and proper case, a high court can in exercise issue a writ, etc., to compel performance, etc. And then, my lord, the last 3 lines. The court may itself pass an order or give directions which the government or the public authority should have passed or given had it properly and lawfully exercised its jurisdiction. And that's what we are saying. You refuse to take up the stay. My learned friend cited, my lord, the earlier order and said this was the order. But did that order provide for an order 19 coming in? Moment order 19 came in, we said, now you hear a stay. Because if you're going to push it for cross-examination, then you kindly hear a stay application. Earlier order can't regulate what happened on that day when they deviated from the earlier order. And court has the power, my lord, pending section 5 to grant, my lord, orders.
Yes. Anything else?
If target dictating, well, can you give us leave to my advocate record to correct two things? One is, if the revision application appellate side is not, that should be deleted, and my lord, the valuation of the proceeding has not been said, that has to be incorporated. Can you keep
I'll grant you that. In your matter, 7.
All both same.
All 7. And you have annexed both the certified copies. Have you disclosed subsequently? Certified copies?
Yes.
There was an undertaking. No.
Yes, that is what the both are the
It's annexed. But on the last occasion, granted that leave.
Yes, that has been annexed.
Yes.
No, that was granted in the earlier revision, which was withdrawn.
No.
No, here it's there. No, here it's there.
When you filed it, I granted with the file without certified copy.
Like to bolche আমি তিনি কেন বলছেন যে leave নিচ্ছি?
No leave. Without leave.
There.
Challenging. Nothing
My
there.
lord, this justice oriented approach, my lord, part of it.
I'll check it. Yes, I'll print. Yes. 403 and 404. Yes. The common order. Yes, I'll pass.
My lord, kindly say, my lord has not gone into the merits of the section 5 application.
I have not. I have clarified that.
Say that. My lord, kindly say
Now,
that.
further.
My lord, once my lord says justice oriented approach, interim.
Absolutely. That is
That's my lord.
yes. Justice approach has to be there.
My lord, kindly say, my lord has not.
I have not recorded. I have not gone that far to record. Only 15 days delay. I have not gone that far. I don't want to close this. You see, Mr. Banerjee, the court is not powerless to pass appropriate orders, as rightly pointed out by Mr. Shah.
Absolutely, my lord.
But considering the fact that section there was delay in such a matter, there was some delay.
My lord, someone is shedding crocodile's tears today. We are drenched
In
by that
this
tears.
particular matter,
Has
there ought
not.
not to have been any delay. Means they ought to have come up at the very first day. Anyway, there was 15 days delay, 30 days plus 15 days, 45.
Kindly say, my lord has not gone into the merits of section 5 application. My lord, this my lord, we are entitled to this observation.
No, Mr. Jha, difficulties, you did not file it immediately within 7 days time. That is the reason why I have not. No, I am not. I am not. That is all right. Yes, I am not. Yes, call the next matter. Call the next matter.
We are saying to die on.
Yes, Wednesday and by 70.
By that, but kindly make that observation that
Whatever is here. Whatever. Yes, call the next matter. Hold on.
My lord, I for the petition. My lord, in this matter, my lord, the ex parte position order was passed by the learned SCGM Alipur without considering but the 9 points of proviso of 14.1. My lord is well aware that the 9 points has to be totally ex parte, no opportunity of hearing to be given. Straight away, police assistance has been given to take care of
Police assistance will not be given, Mr. Pal. You don't want police assistance.
My lord, the proviso, my lord, there has to be test. My lord, the several, my lord is well aware of the several judgment of this court also. 9 points has to be considered. Ex parte, my lord, order of police assistance was absolutely bad in law. That is considered by our High Court also. Even Honorable Supreme Court judgment is there. Considering the Honorable judgment of the Supreme Court, our High Court also passed several judgment and orders.
Which one? Which one?
My lord, what is the
position notice?
Position notice.
Yes.
No, not notice. One of the expert taking position with the assistance of the police. That I am agreed by.
What judgment? What judgment you want to show? Which paragraph?
But on 6th is the last date. On and from 25th December to from the order itself it appears.
Which paragraph?
Starts from paragraph 12.
Show me the facts where the court has decided that this order ought not to be passed. একটা সার্ভিসি এক দাও তো এই।
But I'm coming to that, brother. Well, the starts from paragraph 3. While arguing WB number such as Mr. Basu Lande for the petitioner was heard submitting that law had undergone a sea change in view of the decision of the Supreme Court reported in Monu such and such. Harsad Govardhan Sondagar versus Internal Ashes Reconstruction.
Yes.
An application under section 14 of the SAP cannot be disposed of by the CMMDM granting the prayer for assistance without putting the borrower on notice. Considering such broad.
So you are not put on notice?
No, expertise. For that is I am telling about the expert. Expertise tapes, Malodi, kindly have a look to the impugn order. From will also state to see how have been the order was passed. First on 17th December 2024.
Where have you stated that you have not put on notice?
Well, from the first paragraph itself, my lord, will find. Paragraph 2. Paragraph 1, paragraph 2.
You are on proviso.
Yes. 9th should be, my lord, then
Huh? Provided that on receipt of the affidavit, the authorized officer, the district magistrate or the chief magistrate, as the case may be, after satisfying conditions, pass suitable order for the within 30 days. Which proviso? Which proviso?
section 14(1)(a). Proviso 9th test is there. Amended section 1.
Yes. 1A, yes. Provided that an application by the secured creditor shall be accompanied by an affidavit.
By an affidavit. And that
Yeah.
has to be served upon us. That has not been served. No notice, nothing else. Straight away, my lord, the police station order was passed.
Position has been taken.
Not really.
Challenging the order dated 17th of December 2020.
Public.
Yes, Mr. Mojumdar.
This is an application in public premises eviction act. No, no, no. No copy. No copy. My lord, order dated 21st December last year, 2024. Lord, the order That is why. No, my lord. The thing is this, they already,
21st is the order passed. They given 15 days time. So 6th is, yes, that's all. Oh, okay. I can.
I don't know what is there, my lord, in the matter, my lord, unless I go forward. Yes, my lord.
তুমি
I want
এই তুমি তোমার নাম আর ইয়েটা দিয়ে দাও, অ্যাডভোকেট রেকর্ড আছে, he will provide it.
The PPI proceedings, my lord, PPI orders are appealable orders under section 9 of the public premises eviction of authorization.
That against that order we come here.
I don't know why my learned friend is filed.
my lord, may I tell your lordship one thing?
Okay. Next, stay the chair. ঠিক আছে। এই তুমি নাম আর ইয়েটা দিয়ে দাও, দিয়ে দিচ্ছি।
Next Wednesday, my lord, very well. Very well. We shall submit today, my advocate on record, but kindly pass an interim order till the hearing of the application.
I come back next week with instructions, my lord, and if my judgment wants it to be fixed after 2-3 weeks, my lord, that I was.
Lordship.
My lord, the thing is this.
Lordship, I am handed over a copy. Here.
I accept right.
নেক্সট বুধবার 8 তারিখ বলছেন, হবে অসুবিধা কোনো আছে কিছু?
অসুবিধা কিছু নেই।
হ্যাঁ, তাতে তো এন্ট্রি অর্ডার দিচ্ছে তো, আর তো কোনো
Very well, my lord. If
file was not served. Grateful.
I am grateful.
my lord, the stay is continuing from 2005 till today. No, it's all right. It's all right. But
I am grateful.
but we are not serving the copy of the order because my learned friend is there.
I'm okay.
No, that might get.
All right, we will serve. 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 Will sir.
Very well, my lord. That's it.
ওর নামটা কি?
Item number 11, which Mr. Payne was reading me in the matter yesterday. I received a copy. This particular person, your lordship, represented this particular person. This is going on for releasing the matter. Why not I just received the kind of kindness. Have a look. The case number also received. But I really feel embarrassed. I just really feel embarrassed. My lord, I really feel I just received this letter. So Devabroto Moitri Charitable Devabroto Bandopathy, FA 123/2007. It is fixed for yes, for releasing minor. Yes, server. This is the case number.
আনতে বললাম তো এখানে আনো wait call the list
And for the petition led by Mr. Shuddhadev Adak.
দাঁড়াও এই নাও এদিকে এসো নাও এইটা সোমনাথকে দিতে বলো দাও দিয়ে এইটা দিয়ে ওইটা একসঙ্গে আনবে এইটা দিতে বলো সোমনাথকে আগে দেবে তারপরে আনবে একসঙ্গে এটা আগে সোমনাথের হাতে দাও তারপরে আসবে ইয়েস
My lord, petitioner husband, my lord, file a, my lord, divorce suit, my lord, after that, my lord, wife is the petitioner, my lord, file a written objection, my lord. My lord, written objection, they filed, my lord, their, my lord, profession is, my lord, instead of homemaker, housewife, they written their, my lord, learned advocate, written the, my lord, this is the service. That is the problem, my lord. We made an application, order 6, rule 17, my lord, to the amendment of this, my lord, this portion, my lord. That was rejected by the learned court below.
What was rejected?
My lord, page last page of this, my lord, impugned order, my lord, the order number 10 dated 1st March 2024.
Sorry, sir. Admission cannot be withdrawn.
My lord, problem is, my lord,
from service holder to homemaker, not possible.
No, my lord, kindly, my lord, awardment, my lord, page number, my lord, page number 39, my lord.
Service, she was doing service.
No service, my
There are
lord.
a lot of implications. Sorry, sir.
No, my lord, kindly, my lord, we will, my lord, made an application, a phrase, my lord, kindly, my lord, that opportunity may be given, my lord. Either, my lord, we have no, my lord, my husband.
A subsequent event. Now she is not in service.
No, my lord, she is never service after marriage. My lord, kindly, my lord, she is not
That is
service
not permitted,
at all,
not
my lord.
permitted. Admission cannot be permitted to be withdrawn.
No, my lord,
Admission cannot be permitted. Admission.
No, my lord,
She is in service. Today you want to withdraw that. Tomorrow you will claim maintenance. Arey, what is this?
No, my lord, she is not service. Or it is the fault of the audit advocate, my lord. We have already, my lord, it is a typographical mistake, my lord. This is the by profession, my lord. Other copy paste, my lord. This is the, my lord, service to homemaker, my lord, and my lord, housewife. My lord, this is the problem, my lord. She is not service at all, my lord. My lord, kindly one opportunity, my lord, set aside this order, my lord. After that, my lord, send back to the, my lord, done it court below, my lord. We will fresh application, my lord. Application will consider with, my lord. Lord, husband can't, my lord, show any documents, my lord. I am in service, my lord.
You filed a written objection statement. Why will the husband show, sir?
God, it is a, my lord, it is a typographical mistake, my lord. My lord, what can I do, my lord? My lord, I am the litigant, my lord. If, my lord, today, my lord, I am my fault, my lord, my litigant, my lord, can suffer, my lord.
What service she was doing previously?
Before marriage, my lord, one call center, BPO center, my lord. I was in service in a BPO service, but my salary was, my lord, 7,000 per month, my lord, BPO center. After marriage, my lord, I left this job, my lord. I talked to my client, my lord. This is the happened, my lord. This is the, my lord. After marriage, my lord.
You can explain that. You can explain that, but you cannot substitute it.
My lord, what,
You can explain what you are saying. You can explain by way of an amendment.
because my lord, what is the alternate way, my lord? I can't, my lord, see, my lord.
File a separate application. File an application explaining it.
Either, my lord, this order is, my lord, substance, my lord, without.
You want to withdraw your application? I'll grant you leave to withdraw your order 6 or order 6 rule 17. In revision, I'll grant you leave to withdraw it.
My lord, withdraw means, my lord, either, my lord, order was passed, my lord, my application was rejected by the, my lord, learned court below, my lord. Lord, I have challenged this, my lord, order, and my lord,
I will not allow this order to go through. Please understand the situation. Allowing this with tantamount to altering the nature of work that you were doing previously. You filed a suit.
no, my lord, my husband, my lord, was filed a suit. I filed written objection, my lord. I have filed, my lord, written objection. My lord, written objection, my lord. Yes, so much.
Serve on comeback. I'll reject it. You see, I will only grant you leave to withdraw the application. Order 6 rule 17, I'll grant you leave to withdraw it. Not necessary. You file a fresh one. Explaining this.
My lord, kindly, my lord.
After arguing the matter for some time, the petitioner
The court.
My lord, kindly, my lord. My lord,
I will not grant that.
No, my lord, my lord, kindly, my lord.
I will not grant that.
Not one opportunity, my lord, kindly, my lord.
You explain it. I provided for that.
My lord.
You explain it. You explain that she was not in service.
My lord, kindly, my lord, this application will be considered, my lord, certain period of times, my lord. This is the, my lord, kindly, my lord.
Yes.
My lord, this application, my lord, consider with the certain period of time, my lord, kindly, my lord.
I could not follow.
My lord, we will made an application before the, my lord, court, learned court below, my lord. This application will be considered, my lord, certain period of times, my lord, kindly, my lord.
No, unless there is an
one line,
application.
my lord, either, my lord, because, my lord, kindly, my lord, one line, my lord, as early as possible, my lord.
You,
My lord,
whatever you want to do, you do.
my lord, kindly, my lord, one line, my lord, this application will be considered as early as possible, my lord. My lord, this, my lord, my lord, it is a, my lord, litigant will be suffer, my lord. My lord, this is the fault of this.
Then you
my lord.
don't press this application. Don't press it, withdraw it. You file afresh, go before the trial court. I can record that also, that you all would like to file a fresh application.
My lord, kindly, my lord.
After arguing the matter for some time, the petitioner would submit that yes, this matter I had appeared for whom?
My lord, for Devobruto Bandyopadhyay, these are the set of orders, my lord.
You did not indicate this yesterday. দেখি ফাইলটা পুরো অর্ডার গুলো দাও। হ্যাঁ ভগবান।
My lord, I
asked you
appeared for the
yesterday.
respondent.
বন্দ্যোপাধ্যায় এতগুলো অর্ডার হয়ে বসে আছে।
Really embarrassed to just move your lordship. For the matter, so many times we had mentioned for arbitration.
What is the matter? I don't even recall.
But my lord, that I should.
What is the matter? What is the matter?
My lord, that was rejection of the summary judgment, Mr.
No, no,
Singh.
that is all right. But what is this matter?
That matter I am not aware of it. The order sheet is there because Devobruto Bandyopadhyay is related to Jyoti Kanna Bhattacharya, the mother of the petitioner. There's a letter issued by.
এটা কালকে তুমি মেনশনটা দিয়ে দিও।
Why not?
হ্যাঁ সোমবার তুমি মেনশন দিও। তা না কি হয়েছে? হ্যাঁ
I have served them notice already, my lord. I have already served them notice.
তুমি মেনশন দিলে
Yes, my lord. First to be mentioned. They পরের পাতায় আছে।
দিয়ে দাও ওটা ফাইল তুমি মেনশন মানডে।
এই original letter.
You ought to have checked up, Mr. Bose.
My lord, I really apologize.
It is not possible for the court to remember all this.
I know.
দরকার নেই আলাদা তুই তো মেনশন করে দাও ব্যাস।
No, pardon. Very innocuous prayer, my application under order 39 rule until 2 injunction application that may be disposed of with this specific time bound period. That is my sole prayer. Because it's a partition shoot. In the meantime, my lord, I have obtained a permission for construction of my building. Everything is.
You want your suit to be disposed of?
No, suit I am no injunction application. I'm suffering an injunction. This
So how many interrogatory applications are there?
For last 2 years I am suffering. Injunction order was passed.
Partition suit, you are suffering injunction.
Yes.
Suit for partition, admittedly partition. You are a co-sharer.
Yes.
What injunction you will suffer? You are bound to suffer injunction.
Let that injunction petition be disposed of within a week.
What disposal, sir?
Your lordship kindly sees the nature of the injunction.
Yes, tell me what is the nature of injunction? Status quo.
Yes, mother. Status quo.
I will confirm the status quo. Serve the other side. I'll dispose it of here. Hurry, is partition suit. You are co-sharer, tell me.
Yes, I'm a co-sharer. The administrative position. The administrative position, mother. Once it is finalized, mother, I can go for the.
I will confirm the status quo and how much. What are the shares? Shares are admitted.
Yes.
I will pass a preliminary degree. You tell me.
Your lordship can see that is there. That is there.
Shares are admitted.
Page 14.
Shares are admitted.
Admitted, mother. Shares.
I'll pass a preliminary degree.
Your lordship can see page 14. It's in the absolutely in the interlocutory stage for last 2 years. Let them.
Sir, petitioner is directed to serve a copy of the revisional application on the opposite parties. Lego. The petitioner. How many petitioners are there?
The petitioner is one, my lord.
The petitioners are directed. The petitioner is directed to serve a copy of the. Bring the other side.
Yes, ma'am. Once the injunction
Are you bring the other side and unnecessarily are making submissions now? Injunction you will suffer, sir. You see, at the end of the day, partition suit, there has to be an injunction. Otherwise, it will be creating difficulties, multiplicity of proceedings.
No,
so therefore,
no,
injunction will be.
Because my portion is already demarcated, butted, bounded, and that is recorded in the.
But you cannot sell it.
Certainly, my lord, I cannot. But my
so therefore, can you sell it? Butted, bounded, everything.
I want to sell it. I want to make my residential house because
not now.
My old residential house
not
in a
now.
dilapidated condition.
Not now. You have to wait for the time.
I
will pass the preliminary decree here by consent of the parties. Bring the other side. And appoint a commissioner of partition. Direct the court to appoint a commissioner of partition so that partition can be completed. Dakota Parta.
65. 66. Item number 66. 64.
Board change karo. Board change karo. কত দেখাচ্ছে ওটা? None appears, no accommodation has been sought for. In view thereof, let this matter be dismissed for the court. None appears for the party. Stop. No accommodation has been sought for. Hello. And none appears for the party. আচ্ছা ঠিক আছে বলে দেবো হ্যাঁ বল ঠিক আছে বলো
Lord, in a suit for partition, where there is an order of status quo, at the instance of the opposite party plaintiff, that plaintiff, my lord, filed an application for an order to construct a new house on the suit premises. Though in written statement, my client objected that his father, the original owner Bhavatos Jana, never parted with or transferred any portion of his property in favor of Ashok, my lord, kindly have a look. Their predecessor in interest who purchased the property, under whom this opposite party plaintiff claiming never produced that deed from my father to that person.
You are a co-sharer.
My father was the owner. It is not problem between our brothers. But one stranger filed this partition suit claiming that my father transferred the 25 decimals of land out of his 29 in favor of him. And thereafter 3 transactions was made. The present plaintiff produced the deed other than the alleged deed from my father to that Pulin Pradhan. It is their case, the Pulin Pradhan.
That is not subject matter of consideration now.
A partition should how a new construction to be permitted.
No, you have also applied for the purpose. Yes, repairing. No.
I am repairing and new construction is totally different.
Where is the objection?
My lord, in his
he is a stranger purchaser.
My lord, no, they failed to produce the deed.
Arey sir, is the plaintiff's case a stranger purchaser? Yes or no?
Yes.
So why are you saying no? Yes, he's a stranger purchaser.
Stranger purchaser, but
he does not belong to your family.
No, not family, and it is our case. My father never transferred any property. And that's why, my lord.
Who are you? Profullo Kumar Jana?
Yes.
Huh?
No. Yes, I am.
Arey sir, tell me who are you? Profullo Kumar Jana?
Yes. Profullo Kumar Jana, Shankar Jana, Niranjan Jana, all sons of Bhagavat Jana, the original owner of the property.
And Bholanath Jana, who is Bholanath Jana?
Bholanath Jana, it is their Bholanath Jana's case that my father transferred the property.
How is Bholanath Jana related to you?
It is not related to me. One alleged stranger purchaser, Pulin Pradhan, kindly come to order impugn, my lord.
Yes. So Bholanath Jana is not related to you.
It is a third transferring. Well, kindly see from last paragraph of first page in opposition, the learned advocate for the defendant submitted, got it. Last paragraph from the first page of the order impugn.
Yes.
In opposition, learned advocate for the defendant submitted that they are not admitting the plaintiff's title over the suit property, and for which they have filed a petition for production of deeds, from which the chain of transfer as claimed by the plaintiff will be established. But the clever plaintiff did not provide them the deed through which plaintiff's predecessor, that is my father, their predecessor, vendor in title, namely Bijoy Krishna Maiti and Pulin Pradhan, purchased the suit property from Pulin Pradhan and Bhagavat Jana respectively.
Now the court came to a finding that the plaintiff has prima facie title.
In this regard, he further stated that since the defendant are not admitting the plaintiff's title over the suit property, the plaintiff shall not be granted any permission to construct Pakka building over the suit property, at least till determination of his title. Now, my lord, kindly see. In reply, learned advocate for the plaintiff submitted they could not yet been able to collect the deed through which Pulin Pradhan buy the suit property from defendant's father Bhagavat Jana. But main deed is not there. Subsequent deed They are claiming that we become the subsequent purchaser. How can it be only accepted? If it is within family, no problem. The stranger claiming, but no deed.
Property from Pulin Pradhan and Bhagavat Jana.
Yes.
Bhagavat Jana is the father.
Yes.
And Pulin Pradhan?
Police alleged transfer. That no deed. Thereafter, chain of transfer made in order to deprive us.
Now Bhagavat Jana's title deed is not there.
No, no.
Bhagavat Jana did not execute any deed.
No.
Please, I want to know this. Pulin Pradhan purchased from whom?
It is our case. Pulin Pradhan never purchased. Never. My father never transferred. For that reason, there is no deed from in favor of Pulin Pradhan. Thereafter,
Challenging the order. 2025. 20th February 2025. Affidavit of service you file it, otherwise
First time, my lord.
you have to file affidavit of service.
Yes, on that day. On
Yes, if you do not file it,
No,
order will not
certainly.
be continued
No,
under
no,
any circumstance.
Definitely.
Item number 68.
Your Lordship, I'm appearing on behalf of the petitioner. In this matter, Ms. Shumali Mukhopadhyay is appearing for the petitioner. Your Lordship, she is currently in legs of court number 39. There is another fixed matter at 2 p.m. Your Lordship, I'm praying for an accommodation.
You continue.
I'm not in brief in this matter.
Since an accommodation has been sought for, on behalf of the petitioner, let this matter, on behalf of the petitioners, let this matter stand adjourned and appear in the monthly list of April 2024. Appear now, let this matter go out of the list. Let this matter go out of the list. Since an accommodation has been sought for a revision, let this
Item number 69 and 70.
You continue, sir. No, you start. There is no difficulty. You know what I do usually. We'll go to April, sir. You start the matter. Let me hear what is there. Let me hear from you what is there. I'll consider your prayer later.
My lord, the issue that involves in these two applications, 69 and 70, my lord, involved common question of law. My lord, what has happened is, my lord, the Arbitration and Conciliation Act, my lord, there was an interim order. Two arbitrations are continuing between the parties, my lord. Your lordship is saying the petitioner and the respondent. Arbitration is continuing. One respondent is Birbhum Handloom. Another respondent is item number 70, Birbhum Shopping Mall. My lord, these two arbitrations are parallelly going on. And my lord, we are at the stage of filing of notes. My lord, almost concluded. Now, my lord, what has happened is in course of arbitration an issue involved. My lord, on the basis of, my lord, Mr. Shah is...
Yes. Continue. You are not granted him leave. You continue.
My lord, a question was raised, my lord, whether the mandate of the arbitral tribunal has expired or not. So, my lord, that question is on the basis of section 29A of the Arbitration Conciliation Act, which provides that the arbitral tribunal will have to pass an award within 1 year. Now, my lord, why this question was raised? Now, my lord, we are armed with a judgment, my lord, which indicates that the arbitral tribunal, even though the arbitration proceedings were commenced before the coming into effect of the Amendment Act of 2015, my lord, these proceedings will also be governed by section 29A.
Yes, Mr. Shah.
But may I invite your kind consideration to the
No,
note of argument
Mr. Chatterjee is
filed
appearing
before
for the
the
other side. Mr. Chatterjee is appearing on the
Yes,
other
my lord.
side. So this point would require some consideration.
Lordship. Your question of law, yes.
So I'll place it for final arguments
Yes, please.
as
my
a returnable motion.
Lordship. No,
No scope for any interim order, Mr. Shah.
no, my lord, there's no scope for any.
And the only issue that would be relevant for consideration whether the provisions of 29 capital A1 would be applicable in the present case, notwithstanding the arbitral proceedings having commenced
Yes.
prior to the date on which this act has been
My
enforced.
lord, I really have a twofold submission, if I may just indicate.
No, I'm just trying to find out.
Yes, ma'am.
This is one of the points.
One of the points, yes. My argument is really twofold.
Whether the amendment is to be read as prospective or retrospective.
Aside from that also, my lord,
Yes,
I
yes.
say that aside from the aspect of prospectivity or retrospectivity, because, my lord, the section 21 notice, my lord, was originally issued in 2011. So therefore, the question of prospectivity or retrospectivity comes in. But in this case, the tribunal has been reconstituted from time to time. Lastly, being reconstituted in 2018, after the amendments came into force. 29A became operative. So my humble submission, argument in the alternative is, even if the tribunal being reconstructed in 2018 is to be taken to be the commencement of the time period, time available for passing the award is 12 months from the last reconstitution of the tribunal in 2018. Therefore, 29A will squarely apply even if taken to be prospective only. That is my submission.
What is the stage of the arbitration, Mr. Shah?
The hearing is concluded, notes are filed. Notes are being filed. So we had filed a section 16 application urging this point. The learned tribunal dismissed.
When was this disposed of? Oh, long back.
Yes. March 2024.
No, award has not been passed, is it?
Not yet. Lordship, that is the stage. Order impugned is of 22nd March 2024.
Returnable motion. I'll place it. In February. আগেরটা কত দিলাম?
My lord was pleased to take it up on Monday.
Thursdays.
Thursday. Very good.
This is a returnable motion.
Lordship. Thursday কত?
আর কত আছে? আর কটা আছে? আর কটা আছে ওইদিন? আর কটা আছে?
Thursday 9th.
20 তারিখ অনেক আছে। তার পরের সপ্তাহে? কিসে দেখছো? জানুয়ারি না ফেব্রুয়ারি? ফেব্রুয়ারি, হ্যাঁ হ্যাঁ। On 27th.
Please, madam.
Having heard the learned advocates appearing for the respective parties, I am of the view that this revisional application is required to be heard. Full stop. Let this matter appear under the heading returnable motion on 27th February 2023. It will be taken up, Mr. Shah.
Certainly.
Yes. Mr. Chatterjee would be in difficulty on that date or any other date? Yes. Ascertain. Yes.
I will wait, madam.
Yes. Let him ascertain.
Lordship, noted.
এক মিনিট দাঁড়াও। ফাইলটা তো। Filing in a department. The point of law, pure question of law. It will not take long.
No, it will not. It will not. There are two judgments for your lordship to consider, my lord. There's a list of dates we've set out in our notes of arguments. Parties are added on
The
that.
argument is that since it was reconstituted and reconstitution was after the amendment,
yes,
therefore it would apply.
That is my humble submission, my lord. That is an aspect perhaps that has not found consideration in the impugned order.
On the first question, that's more or less I could has followed that once the perspective after the amendment of the government. But the issue with regard to the reconstitution, perhaps has not been decided by any.
Let us, when we argue the case.
That is why he's saying that this point is still open. Can't say that this issue has been decided finally.
My lord is looking at the order impugned, my lord, last but 5 pages. Counter 69 to counter.
On 27th? 27th.
My lord is
as returnable motion on that date, final hearing, it will be over, I suppose.
I'm sorry, my lord. My lord is pleased to keep it on 27th of January or February?
February.
Very
January,
good.
The list is booked.
be in
Who will not be?
Acting order. Both matters, Mr. Shah. Both the matters.
Well, my lord, subject to your lordship's convenience, can it be 24th? My instructing advocate is not will.
No, only on Thursdays.
the next week.
Then next Thursday I can play. Then it goes to March.
I'm not there.
Then it goes to
We
March.
had misheard your lordship. We were under the impression lordship is pleased to keep it on the 27th of this month.
January. I was. Sir, nahi hoga.
Then take your chance on 6th of March.
6th of March. 6th of March.
6th of March.
Monthly list of March, marked 6th. Returnable motion.
Please, my lord.
Monthly list of March, marked 6th as returnable motion. ঠিক আছে?
Extremely grateful. my
Yes.
lord.
Yes. No difficulty. He's having difficulty, some difficulty on that. Yes, call the next matter. Both the matters, Mr. Shah, both the matters.
Both the matter.
Yes.
Supreme Court the opposite.
বোর্ডটা চেঞ্জ করো, বোর্ডটা চেঞ্জ করো।
My lord.
Who is for the petitioner, sir?
My lord.
Yes, sir.
My lord, in a suit for eviction on the ground of reasonable requirements and default in payments of rent, I am the defendant in the suit filed before the trial court.
Yes.
My lord, the defendant entered his appearance within time and filed his written statement on 2 application 7172. In 72 application, defendant raised a bona fide dispute regarding rate of rent, quantum of arrears, and relationships.
Yes, sir.
And my lord, the learned trial judge directed the petitioner to deposit 1200 rupees per month. Dispose of
Sir,
71.
did you comply with 7.1? Three
lord,
parts.
My lord, no. Admittedly, I have failed to comply with the order.
The matter ends there, sir.
No, my lord, kindly consider one judgment delivered by.
Yes, sir.
My lord. My lord, if the bona fide.
Yes, sir. I will consider, sir. You give me, sir.
My lord, delivered by Justice Honorable Justice Sanjeev Banerjee.
Oh.
My lord, pat on this point, ekdom. My lord, will kindly consider in the light of this judgment. No, I'm going to.
In that matter, his lordship had said with regard to 7.1, this is a little. I have dealt with this matter in another matter. I don't remember who was appearing.
No.
His lordship has observed that this time can be ordinarily section 7.1 application has to be section 7 under 7.1. The deposit is required to be accompanied by an application. Perhaps in this matter, yes. Smart enterprise, Sri Ram Trust.
My lord, kindly allow me to place.
No. Not necessary to go that far.
My lord, kindly allow me to.
Yes. Did I stop you, sir? Why are you saying, sir?
My lord, I will get full.
Please, sir, continue.
First
Proceed in your own way, sir.
My lord, admittedly.
Just a minute. Your defense has been struck off.
No. My lord,
what has been done?
During the pendency of this section 2 application, if defense is stuck out, that order cannot be attained the finality. This has been.
I know that if that judgment reads that defense has not been struck out here.
No.
But here in this case, 7 একটা premises tenancy act দাও তো এই 7.1, so far as 7.1 is concerned, A, B, C, it has 3 parts. Come to the parts. Let us understand one by one. ওই তো ওই উপরের বইটা দাও, হ্যাঁ দাও দেখি। Come to 7.1 first. Let us see the section. We'll go back to the judgment later.
My lord.
Yes. Place it, sir. On a suit being instituted by the landlord for eviction on any of the grounds referred to in section 6, the tenant shall, subject to the provisions of subsection 2 of this section, pay to the landlord or deposit with the civil judge all arrears of rent calculated at the rate at which it was last paid and up to the end of the month previous to that in which the payment is made, together with interest at the rate of 10%. B. Sir, wait, sir. B. Such payment or deposit shall be made within
1 month from the date of order.
From the service of summons on the tenant or where he appears in the suit without the summons being served on him within 1 month of his appearance.
My lord.
The tenant thereafter continue to pay to the landlord or deposit with the civil judge month by 15th of each succeeding month a sum equivalent to the rent at that rate. So what are the three things? Admitted rate, if there is no dispute. If there is a dispute, is a different question altogether.
If there is a dispute, it will
Then-
appear from the importer itself.
Then what is the admitted rate?
It will be
He
admitted.
says 5,000 rupees. Please understand, sir. Slowly, sir. I'm not as fast as you are. He says 5,000 rupees. Plaintiff says 5,000. You say, no, it is 200. So what becomes the admitted rate? 200.
My lord.
You may not pay the balance of 4,800. You may not pay. But 200 rupees
Admitted.
you have to pay. When you have to pay? You have to pay within 1 month,
From the date of order.
not the order.
No. From 1 month from the service of summons, enter appearance, file his application.
And from the date of the order, what you will pay? What will be adjudicated within 1 month or within such further time, not exceeding how much? 2 months. So there is an outer limit. The court can extend it. Outer limit. What? The disputed amount. Admitted amount within 1 month, month by month. Have you complied with that? First tell me.
My lord, with due respect, I have failed to comply with this order.
The matter ends there, sir.
My lord will kindly consider this judgment. In the light of this judgment, my lord will kindly allow me to place
Mushkil
the case.
affair.
My lord will kindly.
Now you argue on this after he concludes.
My
Give him a copy now.
I mean, I refer kindly to 2017.
Buddy. The judgment.
Calcutta. My lord will kindly come.
Where did the court say that you are not required to pay this?
No. I can wait for the final decision of the 7-2. My lord will kindly see.
Show me that.
My lord kindly see.
Ajay, let him show me that.
My lord, paragraph 3. My lord, here also the petitioner failed to comply with the order passed on 7-1 application. He filed an application on 151, praying for leave, praying to kindly allow him to deposit that rent. That application was rejected. My application was also rejected. My lord will kindly straight away come. Paragraph 12 of this application, of this judgment. Since it is the admitted position in this case that an application under section 7.2 of the said act has been filed and such application has not been taken up yet for consideration, whether the petitioner has made the payment in terms of any order said to have been passed under section 701 of the act or not, it is little relevant. Technically speaking, in view of the wording of section 7.3 of the act, an order may be passed for striking out the defense in view of the non-compliance with the requirement under section 701 of the act. But an order under section 7.3 of the said act passed at this stage would not attain a degree of finality because 7.2 is pending. Thus, since the final figure of the amount due has not yet been indicated by the trial court in terms of section 7.2 of the said act, the petitioner herein need not be overly worried at the needless application that the petitioner filed before the trial court. My lord will kindly next come paragraph 13. 13. It is open to the petitioner to make any payment or deposit or to wait for the final amount to be indicated in the order to be passed under section 7.2 of the said act and make the payment within the prescribed time thereafter. My lord, non-compliance will arise from the date of order passed on an application under 7.2 of the West Bengal Penitency Act. My lord will kindly see, but the plaintiff valued the suit 12,000. Learned trial judge directed me.
Why are you going that far, sir? Only on 7.1, 7.2 you argue, sir.
My lord, I leave it to my lord. In the light of this judgment, Admittedly, a bona fide dispute has been raised in 72 application.
Where is your application under section 7.2? Application under section 7.2. Show me. Hurry.
Not annexed. But it will appear for
I'll finish it off. Fine. Give it to me. No point adjourning these matters.
But my 3 point is in.
No.
In 72
Let me find out what is your defense. What is to be adjudicated?
Admittedly, rate of rent, monthly rent. Kindly consider the
No, paragraph 2. You have a copy. Show him, otherwise he will not be in a position to appreciate his own petition. What he has written.
Kindly allow me to first my.
Come to paragraph 2, place it. Yes.
The petitioner has been holding and occupying one room on the ground floor as a mere monthly tenant thereof at a monthly rent of 1,000 per month payable according to the calendar.
No. Monthly rent of rupees 1,200 per month. Instead, it is a instead. So I take it will be instead of rupees 1,000 payable as per. So what is the admitted amount? No, the plaintiff himself received monthly rent up to the month of rupees 1,200. 1,200 admitted.
7.1 says 1,070 get 1,200. But I take it on the lower side
1,000 admitted. 1,000 admitted. You tell me what is admitted.
Now, my lord, kindly see the valuation of the suit.
Forget the valuation of the suit.
If the suit is under,
let the suit go to the Ganges.
My lord, if the suit is undervalued, what will be the fate of the suit?
I file an application, sir. You know better, sir.
My lord, kindly.
Sir, you know much better, sir, what to do in such circumstances. Please. Why are you approaching the court for this? Please. This is not the issue. Your challenge is order under 70.
Admittedly,
order under which order? Which is the challenge? 151 only for bonus.
Beyond 1 month.
My lord,
it is held to be by
my lord,
but not permissible.
My lord, since that application is pending, I can comply with the order passed on 7 April or wait for that.
Pay whatever you want. Without prejudice to your rights. Nobody will stop you. Go and pay. Pay to him directly. He will accept it.
Kindly direct him?
No. Without prejudice to his rights. If he wants to pay, go on accepting without prejudice to his rights. What difference will it make? He wants to pay. Your right is lost. Your defense is will be struck off. Matter will come to an end.
My lord,
I have read that judgment, sir. That judgment will not help you.
Paragraph 13.
So I will explain that, sir. I will explain that. Section 151, what happened to the suit thereafter? End of this month. After the 7.3 order is passed.
No, 7.3 has not been filed.
7.2 order has been passed. No.
That application has not been filed.
Kindly take something into that.
Then why are you moving this, sir? Why would you want to prejudice? This order will prejudice you. Any observation made by this court at this stage will prejudice you, sir. If a 7.2 order has not yet been passed, I do not know what the learned judge will do. Because you see, at the end of the day, the affirmants are very peculiar here. What is being shown to me, and he has not filed it along with the petition. I do not know what is correct.
Allow me to file supplementary affidavit.
He admits.
Then I'll allow him to file supplementary. Why you see, 7.2 order has not been passed. So today he'll be prejudiced. My observations, you are aware what will be.
No,
I'll adjourn this one. Today, I also know what I'm going to observe here. He is also aware of the situation, what this court can observe in the circumstances. And you says any observations made today will have a serious implication directly on the trial court. Your matter will immediately come to an end. Now you tell me, sir, what will I do in this circumstance? Because today is 7.2 is yet to be decided. Why are you pressing this application? Your 7-2 is yet to be decided.
My lord will carry directed trial that to dispose of the 7-2 application.
Yes, yes. No, no, no. I will direct him to reserve.
No.
Why? 7-2.
Because the law is not be along with 7-2 has deposit the
If he does not, he'll reject it. Reject it.
Statement permission.
So, my lord, disposal.
No, reject it. If it is not in accordance with law, reject it. Absolutely. Everything, sir. The learned, the Mr. Satya, learned advocate appearing in support of the revisional application. Sir, at least your difficulty is the moment you make submissions, and if I decide anything here, that will prejudice your section 7.2. Whatever, I do not know what will happen there.
My lord.
May I call the next matter? It should be there in the file. Yes.
I appear for the respondent petitioner. Act 8 case, my lord. The wife is the respondent there, my lord. Wife has come up against an order in a section 12 application for interim custody filed by the father. Now the child now is of 6.5 years of age.
Child is with whom?
With the father. Father filed the application restraining order.
What are you doing?
My lord, wife is not doing it.
What are you doing?
Wife is not
working?
Right now, not working. My lord.
She was working earlier?
She was working earlier.
Where was she working?
In a airlines.
Air hostess.
Mr. Chatterjee is appearing. Now, my lord, here what happened, my lord? Initially, section 12 was filed, an interim order was passed, ex parte interim order, by which, my lord, on the first day in my absence, an interim order was passed, restraining me from having access to the child. Only at the wish of the child I can have access. That was the order. Anyway, that was passed. That was challenged before this honorable court, and against some other orders, my lord, some other revisions were filed by the husband.
What happened to that order? That order continues to be here.
That order, initial order. Then, this honorable court, in one revision, framed a scheme of visitation. A scheme was framed by Honorable Justice Sarkar, in which my lord, that was restricted up to the period of summer, winter of 2023. 23 end, the dates were given, how the visitation shall take place, that was framed. Then, my lord, my challenge was disposed of by saying that since the scheme has been framed, it becomes infructuous.
What are the allegations against you?
Allegations, my lord, both have alleged adultery against each other. Violence,
Forget that, adultery is different.
violence, my lord, cruelty, physical violence, all allegations are there
On
from
the
both
child?
sides. No, on each other. And
Any
now they have
allegation
filed, now
so
they
far
have
as the
filed,
child is concerned?
so for the child now, after during the visitations, my lord, they have filed one FIR that I have harmed the child bodily, which is not why the mother will harm a 6-year-old child. Yes, they have filed the allegation. They have made the allegation, FIR has been
The
filed.
child goes and spends the night with you.
That has not been allowed, my lord. That is one of my prayers, not what I am submitting, my lord. This interim order, your
Yes,
lordship will
Mr.
sign.
Chatterjee.
My prayer is not let both the sides, because that
Yes,
scheme
Mr.
was
Chatterjee, you
restricted.
don't want the mother to be close to the child.
Kindly have a look at the order, my lord. The order gives the right to the mother. Have a look at it.
What yes, tell me what is the nature of right?
Exactly. Kindly have a look at the right at the end, my lord.
Yes. কি চাইছো বলো? কি চাইছো?
Now, what I am submitting is, my lord, let
Mr.
both
Chatterjee,
sides
you have
come
to
up with
come
a
to court
scheme.
to argue this matter, Act 8 matter.
I will. My lord, I'm a little down.
All right, I'll not take it up today. Act 8 matter. I'll give priority to these matters.
Keeps it on Monday, my lord. I'll be there.
Monday's monthly list. Let it appear in after you mention it. Oh, monthly list যদি আসে তো গ্রুপ 1 এ আসবে তো। এ তো গ্রুপ 1 এ আসবে, উপর মাথার দিকেই আসবে।
On Monday, because
just not today.
Only not today, because on Tuesday, my lord, oh, it shall again come up, my lord, because if
This
if
will
is
be,
the first,
this
my
will
lord,
not go
it will not
back.
go.
Yes, because only not today.
Only not today.
So this will be in the group 1. And this is an Act 8 case, because Act 8 case I generally do not do on VC also.
No, my lord, it's just my fault. I was completely under the weather, my lord, with a lot of fever. That's why.
Similar scheme
Nothing will happen.
My fault.
No, nothing will happen. I'll fix it on another date. And you have to also think it in a different way. If you
Absolutely, my lord, I am not even going to make submission that the mother should not have access.
You may be in a very difficult relationship with your husband. Or Mr. Banerjee's client may be a very difficult relationship with your husband. You may be a very difficult relationship with your wife. But what about the child?
Absolutely. But I am not going to make that submission at all. We have to find out a way. We'll find out a way, my lord, whichever is better.
Close to the mother or the father, whosoever it is, in the receiving end, the child will never come to know.
Bow down.
Deprived of the benefit of the love and affection of both.
And bow down.
The loss that will happen, that is irreparable loss. And please don't forget, at the end of the day, this child will someday or the other question that why was I deprived of this benefit?
The problem is, my lord, this what your lordship is saying has to come down to both parties. This is what the problem is. Mr. Banerjee's client, my lord, this matter has a checkered litigation.
Their respective suggestions.
And the learned advocates, such senior advocates of Calcutta High Court, I'm sure that they can certainly work this out.
Lord, this matter has a checkered history.
And I'm seeing in other matters orders, I'm seeing where you see Mr. Chatterjee, where I find that visitation is being granted in some mall. 5-year-old. This is
I don't.
Can't even consider that how will a 5-year-old visit a mall with his mother? Very difficult, this is the situation.
This has become a trend. I don't know from where.
I can understand very well. But it strains your child also at the end.
Absolutely. He needs to be, my lord, in an atmosphere which is congenial, which he is used to, which he likes, which he is used to. And this is required to be understood, my lord, by both parties, not just the father or the mother. Both of them have to understand that by litigating.
Not do it on VC. You see, I usually don't do it on VC.
No, he can
because
his.
No, he'll come down. He'll come down. You go and meet him.
Yeah, I shall.
He is not averse to this. He has openly said that he is not averse to.
Today he is a little down. I heard.
Yeah, it's all right. On the next day, it will be there in the list. Called on.
Definitely.
If he is not called on, mention it, Mr. Manager.
My lord, I shall.
So grateful, my lord. But I was hearing, my lord, I wore my gown. But in the morning, your lordship was chastising a lawyer for wearing a gown, my lord, on VC.
Not wearing a gown.
Yes, but we were told, my lord, that on VC we should not be wearing a gown.
Not wearing a gown.
The protocol was on VC, my lord, because it's not inside court, so you cannot wear that gown. So that's why I wore it, my lord, because after I heard your lordship, I wore it. I didn't want
Mr. Chatterjee, you see, VC is only a means of addressing the court. But
Yes,
when you
my lord.
address the court,
I completely bow down. Since I'm inside the court, I should be in a gown. I completely bow down.
outside, you see, when you're addressing the court,
When
even
this
through
rule was framed,
video
there was no
conference,
VC. When this rule was framed inside the court, there was no VC. So it
Yeah.
was not visualized at that point of time. What will have to be
at the end of the day, Mr. Chatterjee, you are addressing. Now, the place where you are addressing, you have to ensure that is not from a car.
No.
Address a court from a running, moving car, you can't do that.
Absolutely not.
VC is for the purpose
But
of.
it's a very good system. At least we do not abuse it.
Yes,
It's a good system. We should not abuse it. I completely bow down, my lord. Completely bow down. The problem is, my lord, moment we get something, my lord, we start abusing that system.
It's always, VC is always open, it's always there.
Yeah, it's very convenient. At times like this, my lord, when your health is really down, it's very convenient.
Not only health is down is one part. The other part is, you see, you get to hear people from different states also. I was taking up Group 4 matters when people used to argue from other states.
Yes, yes. Even we argue, my lord, it's
given on the list, and everyone can access. Anyone wants can.
My lord.
And this is the reason also. This is a pitfall. This is the reason also why I insist that so far as this order Act 8 matters are concerned, or custody matters, or
matrimonial matters,
all matters, these matters can't be taken live. You see,
no.
One thing is it can be broadcasted live. Secondly, also because here you can record this.
Yes, yes.
I'm not saying that you are recording. I'm not saying.
And send it, my lord, to the social media on the recording.
That is the difficult part, and
I bow down, my lord. I bow down.
That's the downside.
Absolutely. But there are good sides, there are good sides, there are bad sides.
You have to accept the situation. With passage of time today, we are all accustomed to this. This is going to happen. So,
absolutely
worried about accepting for the fact. At times, ordinarily, we never take the name of the child or clients, because here a person's life is at stake, his reputation is at stake, allegations are very serious. So I think that should be confined within the boundaries of the court, not necessarily always in camera, not necessarily.
No, I completely bow down, my lord.
But that should be within the confines of the court. If anyone wants to come and hear, let him hear inside the courtroom.
Yes, yes, absolutely, my lord.
Yes, very well. Call the next matter.
So grateful to Lordship.
Original side, the original side.
My application for expeditious disposal.
Oh, 3:30 আছে না? 4টের সময় আছে, তাহলে original side দিকে। Come tomorrow, come. Original side দিকে। হ্যাঁ, 4:30 সময় আছে তো। হ্যাঁ। In camera আছে না? In chamber আছে। তাহলে in chamberটা কি আগে করে নেবো? ওরা আসেনি তো, 4টের সময় হবে, তাহলে in chamber 4:30 আছে। 4:30 দেওয়া আছে in chamber, 4:30 হবে। এটা 3:30 অবধি করি। Original side দিকে দাও, তাহলে বেরিয়ে যাবো।
Item 75.
Yes.
77 and 95. These are connected matters. But other side is not here.
Sir, I am appearing in the other side for my senior advocate Surodipta Banerjee. I am praying not today.
No, not today will not do, sir. Yes.
Because there is no scope for any interim order.
This will group 1. This will all be retained in group 1. Whatever has been exhausted, those will go at the back of the list or whichever way. These will be called on first.
We'll keep a watch.
So it will be there in the monthly list only. So it will top of the monthly list. May not be 3 or 4, maybe some not today, but may not be at the bottom also, because it may be around 3 or maybe 10, 15, maybe 10, 15 matters it will be there. The other side is not there today.
Yes.
Have you filed a caveat?
Their application.
Oh, your application?
They are not interested.
No, if their application, then I will place it at the bottom of the list.
That is up to them. I will not say anything.
No, I'm not called in, Mr. Mr. Manager. I'm not, Mr. Sen, I'm not called the list.
No.
So I will not prejudice him.
And it is a very old order. I don't think they are very interested.
But he'll be called on immediately. Come back immediately.
December
Monday
23.
itself. Monday itself might be called on. Yes, call the list. তো আর কিছু হবে না, কিছুই হয় না। তো কতগুলো অ্যাপলেট সাইডে হচ্ছিল, দেখো ডেকে যাও। ব্যাস ওকে ডাকো, প্রসেনজিৎকে ডাকো। যদি হয়ে গেছে তাহলে আবার অ্যাপিলেট সাইডে ফিরে যাও না, 2-4টে অ্যাপিলেট সাইডে যদি কেউ থাকে ডেকে নেবে, তাহলে হয়ে গেছে, তাহলে অ্যাপিলেট সাইডে ফিরে যাও, এটা চেম্বারে পাঠিও। অ্যাপিলেট সাইড ডাকো আবার, হ্যাঁ অ্যাপিলেট সাইড ডাকো আবার, অ্যাপিলেট সাইড ডাকো, ডিসমিস করবো না, ডাকতে থাকো অন্তত। হ্যাঁ পার্টিস থাকলে দেখে নেবো। এডি করে দাও, এডি করে রাখতে থাকো, যদি বোথ পার্টি মানে পিটিশনার থাকে নেবো। ডাকো ডাকো। Not today. ডাকতে থাকো একটা একটা করে, যদি কেউ আসে। আস্তে আস্তে ডাকো, আস্তে আস্তে ডাকো, ডাকো।
17, I am for the petition.
Yes, sir.
Well, experience hearing, my lord.
দেখি দাও দাও দাও, বেবি।
Well, they have already interim order status commanders.
Wait, sir, wait. Yes.
Well, last page, my lord, only. Experience hearing, my lord. The obtained day-to-day everyday extension, my lord. The status quo is there, my lord. I am not being able to construct my construction, my lord. It's a cost schedule, my lord. Last page, only last page, my lord.
Any injunction application pending?
No, my lord, no injunction application is pending, my lord. It's not been heard till now.
So you want disposal of the injunction application?
Disposal of the entire suit, my lord.
No, we cannot. Injunction application unless it disposal of suit cannot be disposed of.
Time on. Last for hearing injunction application extension, last line. Again, date has fixed, my lord.
You are for the defendant or the petitioner?
I am for the defendant petitioner. I am suffering, my lord.
আসুন, কি আছে? কেউ নেই? হ্যাঁ ডাকো 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 ডাকো। এটা করে দাও। চাই কিছু? আমার বই ভালো, দেখিনি চেম্বারে গিয়ে। The instant revisional application
No, negative.
I know this is not a mentioning time. This is an extreme urgency. I could have gone before the DRT, but my lord, my property is not a secure asset. I learned it. DRT has paid to appreciate that. My property
Not
has
now,
been-
Monday, not now.
Thank you. Kindly excuse me.
No.